And I think one thing that I really like about the firm, and I think is great, is that we're truly international and multicultural. And we have lawyers coming from more than 75 different countries around the world. And as Sam said, we try and mix local knowledge with international know-how to best structure projects in the different jurisdictions in which we act. And maybe just sort of briefly on Africa, we've made the strategic choice to work with independent law firms in each relevant jurisdiction. And we find that gives our clients just a strategic advantage of being able to work with the best firms in each relevant country. Just briefly on the project finance or energy and infrastructure front, we're band 1 ranked in all the relevant major jurisdictions. We have about 80 lawyers focusing on project financing, spread mainly across our New York, London, Paris, Abu Dhabi, Dubai, and Singapore offices. And we really focus on accompanying our clients across the full life cycle of a project, everything from structuring, negotiating concessions and joint venture arrangements, project financing, M&A, exits, and disputes. So it's probably enough about us and time to sort of get into the crux of the subject. And so I'll hand back to Sam, who's really, I hope you don't mind me saying this, Sam, but really one of our best and brightest experts within the firm on project finance. And he's going to take the lead with us today to take us through the subject.
Thanks, Lachlan. No pressure. So I think just before we get into the substance, just a kind of general housekeeping overview type statement. So we've been asked to present today on kind of an introduction to project finance, right? And we've been given an hour to present with some time for Q&A at the end. And this is an incredibly broad topic, right? And we have tried to break the topic down into sections that make sense and that are kind of consumable within the time. But we could easily do an hour on each of those sections, right? So in the interest of time, we're going to be keeping this presentation very high level and moving through the content very quickly. So if there are things that are unclear or there are things that you'd like to kind of discuss in further detail, we can maybe pick that up in the Q&A, or we can circle back offline. We can do a deeper dive, but do forgive me if we move through things quite quickly. It's just constraints of time. And I think the second kind of introductory comment I would make is that, you know, what we're sharing today is an introduction to some of the key principles or general characteristics of project finance. And as I was saying, you know, it's a very broad topic and we have a very diverse audience attending today. So we have tried to kind of take a kind of middle of the road generic perspective. And it's important to remember that project finance and the transactions that are project finance do not exist in a vacuum. And the practice or application of project finance principles differs depending on the nature of the project, the jurisdiction of the project, the parties involved, the market conditions. There are so many different things that affect how a project is financed using the project financing techniques that we'll talk about today. So I guess the moral of the story is that while today there are some established key principles of project financing, which is what we're going to talk about today, in practice, the application of these principles will vary from project to project. So please remember that as we go through, there will be nuances and there will be differences. And we can talk about those maybe if we get to connect separately. So onto the substance then. What is project finance? Now, you know, project finance is effectively the financing of the development of an asset via a special purpose vehicle, which is a company, a corporate entity that's incorporated for the specific purpose of owning the project, where repayment of the loan or the financing that is used to develop the asset, as well as equity return to the investors in the asset, is financed solely by revenues generated from that same asset, right? So project finance is where you're really looking at single projects or a single portfolio of projects, and the financing is for a specific purpose of developing and operating those projects. And the financing is repaid solely from those proceeds, right? And that leads me into the next kind of key point. A key feature of project finance is that it's an example of what we call limited recourse financing, right? Which means that the lenders who provide the financing to the project have limited recourse to the assets of the ultimate investors in the project. So put simply, the investor's liability for the debt that they borrowed is generally limited to their equity contribution in the special purpose vehicle, or what we would commonly call the project company. So I've used a lot of words here, right? maybe it would help to have an example, right? So let's say that I have a company, let's call it Samco. And Samco is a conglomerate, does lots of different things. We make suits, we sell coffee, we sell computers, we do lots of different things. But I'm an entrepreneur, and I see an opportunity in the power sector, and I think that I can make a lot of money developing a power plant. So I go about doing that. So let's say that the cost of the power plant is $100 million, and Samco doesn't have that kind of cash sitting around in the bank. So we're looking at ways that we can use project finance to fund the development. If Samco was going to utilize project finance to do that, what Samco would do is to incorporate an SPV, a company that would sit below Samco. We can call that Sam Power. And Sam Power would then be the entity which would develop and own the power plant. It would also be the entity which, utilizing project finance, would borrow the money to develop and build the plant, and would also therefore be the entity that would be liable to repay the loan. Repayment of the loan that is borrowed by Sam Power would be solely from the revenues generated by the sale of the power that the power plant produces, right? And before lending me the money, lenders would expect Sam Power to be able to prove or provide comfort that the anticipated revenues from the power project will be able to repay the loan. And the way that you typically do that is by having a long-term contract that guarantees the revenues that will repay the debt. Now, with any kind of asset financing, the bank is unlikely to give Samco, or Sam Power rather, 100% of the capital needed to develop the project. So similarly, in this scenario, the bank is going to ask Samco, as the ultimate owner, to fund a portion of the development costs of the power plant in the form of an equity contribution to Sam Power. Now, the size of the equity contribution, and this is just to take a step back and make it simple. This is very common to if somebody was buying a house, right? And you were using a mortgage to buy a house. Very rarely you get a 100% mortgage, right? You'd have to put down 5%, 10%, 20%, depending on where you are. And in the project finance world, the size of the equity contribution depends on a number of factors, but it primarily comes down to the level of the risk that the bank is prepared to take on the project. And we can pick a typical number here of 30%, right? So the bank has asked Sam Power to put in, or Samco to put in 30% of the project cost as an equity contribution. So this means an equity contribution of $30 million out of the 100 million that Samco has to fund, and results in what we call a debt to equity ratio of 70% debt and 30% equity. So let's assume now that everything goes well and Sam Power borrows the money to build the plant, and things are operating and everything's fantastic. The loan's been fully dispersed. So now Sam Power owes 70 million plus interest and costs. Now, if the project goes horribly wrong and Sam Power ends up defaulting on the loan, then the lender's only recourse is to the power plant assets themselves and other various pieces of project-specific security, as well as Samco's shares in Sam Power, which Samco has effectively paid the $30 million for. So in summary, notwithstanding that the project costs $100 million to build, and Sam Power has borrowed $70 million of that $100 million, if the loan defaults because the project fails or there's a problem, Samco, as the ultimate investor, the sponsor in the project, is only liable for $30 million equity that it funded, right? All other liabilities sit off Samco's balance sheet and reside with Sam Power, which is an SPV, right? And this is the beauty of project finance, off-balance sheet financing, limited recourse to an investor. Now, there are some specific exceptions to the whole limited recourse rule, such as completion support, etc., which are probably beyond the scope of this discussion. But a basic principle that you should remember is that project finance is limited recourse. Some people would describe project finance as non-recourse, but I wouldn't describe that as an accurate description for the reasons that we just discussed now. So that's project finance. Project finance can be contrasted with corporate finance, or what you might call kind of typical bank lending, right? Which is where a company takes out a loan from a bank or from a group of banks, and this loan acts really as a capital injection into that company's existing business, right? And if you take Samco as an example, right? Samco, as I said to you, does many different things, right? If Samco just went to the bank and borrowed $100 million and said, I want to use it to build a power plant on a corporate finance basis, it would be Samco and not Sam Power, not the power plant underneath, that would be the borrower and would therefore be liable to repay the loan, all right? So the key distinction here is that in this situation, the liability to repay is not off Samco is the ultimate investor's balance sheet, right? And that is, I think, the key distinction between a project financing and a corporate financing, right? And in that regard, repayment of a loan that's been granted on a corporate finance basis comes from the company's general revenue sources, whatever they may be, whether they're related to the specific asset that's being financed or not. And similarly, the loan may be secured by all of the borrower's assets, regardless of whether or not they relate to the purpose for the funding or otherwise, right? So that is kind of project finance 101 definition and contrasted with corporate finance. There are lots of other types of finance beyond just loans, and project financing is really a source of loans. Obviously, you've got bonds, equity finance, you can do securitization. There's lots of different ways to basically borrow capital, which are, again, beyond the scope of this presentation. But we thought it would be a very helpful illustration because project finance and corporate finance are often confused. And the whole idea of recourse and the difference in approach to recourse in the two methods really does illustrate the differences and the uniqueness of project finance. So just continuing the theme, I think that this slide shows some of the key similarities and differences between project finance and corporate finance. I think the examples that we just went through really illustrated it well. And as we've already discussed, recourse is probably the biggest difference, but a few other kind of key differences to highlight here. Just picking on the slide, debt repayments here. So debt repayment and kind of tenor, which is the duration of the loan. In a corporate financing, lenders will want the borrower to start repaying the debt much sooner than they would in a project financing. And similarly, the debt is usually repaid over a much shorter period of time. Whereas with a project financing, you typically won't start repaying the debt, or at least the principal amount of the debt, until after the asset is built and operational. And typically, you would repay the debt over a longer period of time. It's talking 10, 20, 25 years, whereas you get much shorter tenors with a corporate financing. And I think that the key thing there is, okay, well, there's a very commercial aspect to this, right? How will the project operate? How will the earning and revenue profile of the company or the asset that's being built, what will it look like in the early years? Can it afford to repay debt over a shorter period of time, given that the debt installments will be bigger? If not, maybe project finance is more suitable. So there's a very commercial consideration that goes into choosing the financing method, as well as just looking at these two things as distinct concepts. And another point to flag is the documents involved or the structures involved from a legal perspective. Now, corporate finance is much easier to execute and to implement, right? In a corporate financing, there are fewer documents, fewer contracts, and most of these contracts follow established market forms. For example, you may have heard of the Loan Market Association, which is a financing industry body that publishes standard form finance documents that basically set the industry standard. Whereas the contractual structure for a project financing is much more complex and often much more bespoke, and therefore can be much more difficult to implement and take much longer, and also be much costlier to implement. I think another key distinction, and I'll stop here, is lender control, right? So in a corporate financing structure, typically once you have borrowed the money, lenders will generally leave you alone to get on and run your business, right? Now, the loan documents will, of course, have covenants and ratios that will need to be adhered to. So you can't just go out and borrow $100 million and go to Las Vegas. No, there will be certain controls. But the controls in a corporate financing are generally much lighter than the lender oversight and controls that you will see on a project financing. In a project financing, lenders are much more in your business, right? Particularly with regards to technical aspects of the project, when the project will be deemed complete, changes to the project infrastructure, changes to any contracts with third parties. Lenders will perform extensive due diligence on the project upfront and on an ongoing basis. And all of this is really because the lenders are solely reliant on the performance of the asset and the revenue contracts with third parties in order to get paid. So again, the degree of lender oversight is a key distinction between corporate finance and project finance, and a key kind of point for consideration when determining which structure or which financing method you will use. So with that said, when is project finance typically used? Well, you often hear project finance most commonly being used in the financing of energy and infrastructure projects, right? And the power plant example I gave earlier is a classic example of something that would lend itself well to project financing. However, project financing can be used to finance virtually any asset with a distinct revenue stream that is therefore capable of supporting the financing. And outside of power, you see project financings in oil and gas, and oil and gas kind of production assets, as well as infrastructure assets like pipelines and storage facilities. Similarly, roads, toll roads is a classic example of where you will see project financing used, but also in less kind of obvious examples, such as hotels and stadiums and mining. You see project financing principles and products being applied across the spectrum. So why would you use project finance? So I think a key thing to note from this slide is that there are a number of different parties that utilize project financing from different perspectives, right? And if we go one by one, governments, how do governments play a role in project financing? Well, what often happens in many jurisdictions around the world is that governments will tender PPP projects, public-private partnership projects, to be developed on a project finance basis. So, for example, in the Middle East, where I am based, all of the utilities infrastructure in the Middle East has been developed on a PPP basis, right? Which is where effectively you have the private sector that come in, they develop a power plant or a water facility, and they finance that development on a project finance basis. And then they sell the power or the water or whatever it is back to the government at an agreed tariff, right? And so this is the government not being the borrower in that scenario, but being an active participant in the project finance market and enabling the development of infrastructure. Now, from a government perspective, this is fantastic because it enables the government to basically push the upfront funding and development risk for key infrastructure onto the private sector, right? It's a way of them getting their infrastructure built with very little money spent upfront, right? And I think beyond the kind of pure economic argument, it's also a great way for governments to be able to encourage foreign direct investment into their countries, because they can tender these projects internationally to people who have a great reputation for developing them, and therefore kind of enabling a knowledge transfer. They can import expertise and get kind of projects built and operated in accordance with international best practice. Moving on to lenders, right? Lenders like project financing because it's basically a product that they're selling, right? They can charge for it. Project financing comes at a premium, and so it's a great revenue stream for lenders. And what we're actually seeing in the market now, that when you have attractive projects with attractive sponsors, there's competition between lenders. They're fighting and falling over themselves to be able to lend to what they see as compelling projects, because they see them as such great revenue streams. And I think also it's important to note that a well-structured project finance transaction is relatively low risk to lenders, right? As we said, you're talking about structuring a project in accordance with international best practice. There's a lot of lender due diligence and there's a lot of lender oversight. So notwithstanding that they are technically higher risk projects because of the limited recourse, lenders get very comfortable lending to project finance transactions, especially where you have strong sponsors or where the technology risk is not great. And I think a point I would note from a lender perspective is that very few project finance projects fail, right? There are often issues with projects in the construction and operation phases, and some of these projects are often restructured to account for these challenges, but they rarely fail. And I, for example, have never been involved in a project that has totally failed. And I think that kind of gives you some gives lenders a lot of reassurance that even if they do get into a project that is somewhat risky or doesn't quite pay off, that people usually work together to find a solution to keep the project viable. And finally, sponsors or investors. Why would sponsors or investors use project finance? Well, primarily for the reason we've already talked about, in that it's off balance sheet, right? And they like that they can get things off their balance sheet, limited recourse, and that helps them from a financing perspective and also to help them meet their commercial objectives. But I think importantly, something that's underestimated in project financing is that there are a lot of sources of liquidity in the market, right? So there are lots of different investors and institutions that are providing project financing products, right? And some of those include ECAs, which are export credit agencies, which are basically government-owned banks, which provide financing often on a limited recourse basis to project sponsors in exchange for those sponsors buying equipment from that country. So it's designed to facilitate trade. DFIs, development finance institutions, like your AFDBs, for example, who provide project financing with the sole purpose of encouraging development in specific areas. And then you have your commercial banks, right, who are providing project financing really just to make a profit. But when you put kind of all of these different liquidity pools together, if you have a large infrastructure project that is very expensive, Typically, you will only really be able to raise the financing required to develop that project by utilizing all of these different sources of capital and therefore using project financing methods. So what are the disadvantages of project financing? We talked a lot about pros, so what are the cons? So a couple of them we've already touched on, and the first two probably go together, which is that PF is very complicated, right? And as we've said, given the level of lender control and lender scrutiny, there are a lot of very, very, very long documents that go into putting a project financing together. And in addition to that, lenders will often perform extensive technical, financial, and legal due diligence on all aspects of the project before they commit to lend. And as a result of that, project finance deals are typically longer to implement and costlier to implement when you factor in all of the time, the advisor costs, and all of the kind of opportunity cost of the time and the advisor costs. And I think an important point to note about project financing, and this is for all of the clients out there, right? This is me having a bit of a rant as a lawyer, in that people think that because the cost of the project is lower, that the cost of implementing the financing should necessarily be lower. And that is true to an extent, but there is not a direct correlation, right? Whether the project costs 10 million, 100 million, or 10 billion, if you are financing it on a limited recourse basis, there are steps that need to be followed, there's due diligence that needs to be done, and there are documents that need to be put in place. And as a result of that, you know, whether irrespective of the size of the actual project itself, the process still remains long, still remains complicated, and still remains expensive. So that is actually some analysis that sponsors often have to do, is does the cost of implementing the project financing justify, do the benefits of the project financing justify the cost and the time? The other one I also mentioned, higher debt pricing, and this is primarily because project financing is a limited recourse product, right? So this means that theoretically lenders are taking a greater degree of risk on the project financing because they don't have risk to a broader pool of assets or to an ultimate kind of creditworthy borrower, and this risk is often priced into the debt. Higher transaction costs and lender oversight and control we've already talked about, so I will skip over them for the time being. So this slide shows what we would kind of describe as a typical contractual structure for a project financing deal. Now, hopefully the sheer number of kind of blocks on this diagram kind of illustrate the point I've been making about how PF is complex and how there are a lot of contracts. And as you can see, like all of these blocks here represent a different agreement that you would see in a typical project financing. And these are just the commercial agreements. And each of these agreements have their own kind of commercial considerations and analysis and process that needs to be followed. And I think that generally the documents comprising the project financing can be placed in two categories. You typically have what we call the project documents or the project agreements or the commercial agreements, which are the agreements that govern the kind of various commercial transactions that are required to implement the development and operation of the project. And roughly speaking, that's kind of like these agreements here. Right, and by way of sample, you've got your feedstock supply agreement, your EPC contract, which is a construction contract, your operation and maintenance contract, and your offtake agreement, right, which is the contract that you will use to basically sell whatever the project produces. And then the kind of second category would be the finance documents, and finance documents are those that kind of relate solely to the loan that is used or taken out to finance the development of the project, right? So this loan agreement governs the flow of funds from the lenders to the project company, and then obviously from the project company back to the lenders as the debt is repaid. And you can see that here, the CTA, that's a common terms agreement. Then you might have individual facility agreements between the various lenders, and then there'll be a whole heap of security arrangements, mortgages, assignments, etc., direct agreements, etc. Now, we are going to talk a bit more in detail on some of the dynamics and mechanics around these various contracts, so I won't spend much time on that here. But one point I would highlight, right, is that you can see that project company is very much the nucleus of this structure, right? Everything goes through the project company, all right? And the project company is an investment vehicle for the sponsors who are the proponents of the project. You can see the sponsors here. This would be Samco in my example. This would be Sam Power in my example. And I think that, you know, you just always have to remember that notwithstanding that the project company might not actually be incorporated until very close to the financial close of the transaction when the project is actually going to be built. So it may not exist for most of the time that you're working on a project finance transaction. And you will probably be dealing a lot with the sponsor, because the sponsor is ultimately the investor that is driving the project. But it's important to always remember that the sponsor and the project company are different entities. And the dynamics can be interesting because for the most part, the interests of the sponsor and the project company and the lenders are aligned, but that may not always be the case as you are going through a transaction. I think the other point to note is, the example I gave was very simple, where you had a sponsor and then a project company, SPV, that developed the project. But it's very typical that you actually have corporate structuring above the project company level. So you may have a holdco structure, you may have multiple sponsors that form a consortium and invest through the holdco structure. You may have a mixture of equity subscription and shareholder loans, which is effectively a form of equity also. So in addition to kind of thinking of project finance as a financing discipline or an energy and infrastructure related discipline, there's often a lot of corporate structuring involved here to make the whole structure work. And particularly to give the investors optimal tax treatment. So the holdco here might be offshore, for example, to enable a tax efficient investment structure. Similarly, shareholder loans are often used as opposed to equity subscription because they're deemed to be more tax efficient. And you may also have, for example, local ownership rules that you need to structure around. So typically lenders would require, and host governments would require, that the project company is incorporated in the same jurisdiction as the project. So if you're doing a project in Nigeria, you typically have a Nigerian incorporated SPV. Or for example, in the Middle East, in Saudi, you have a Saudi LLC, for example. But there are ownership restrictions in many countries around the world where these companies have to be majority owned, for example, by a local shareholder, which may impact the governance that you have at the project company level, which may not be the governance that the investors actually want to replicate. So what you often see is you have a holdco structure implemented offshore in a structure where you can have whatever governance you want, and all of the governance happens here at the holdco level, to give the investors the kind of decision-making rights and governance rights that they want. And that's effectively a way of kind of circumnavigating the local shareholding restrictions at the project company level. So I think that's what I will say here. As I said, we'll come and talk about a lot of the contracts shortly. I want to move on and talk very quickly about risk allocation and bankability. All right. And these are two kind of, I would say, overused phrases in the project finance vocabulary that if any of you have experience of project finance, you would have heard these phrases. Now, what do we mean by this? Now, projects don't exist in a vacuum, right? They exist in real countries. They are physical assets, operating assets, and therefore they have to interact with physical, political, and socio-economic environments that exist around them, right? And this inevitably means that any project will be faced with certain risks. And we'll talk about what some of these risks are in a minute, but a key aspect of any project financing, and I think more importantly, the key role or a key role of any lawyer that's advising on a project financing, is helping to develop a legal and commercial structure that allocates responsibility and liability for the various project risks in a way that is both appropriate and commercially acceptable to all of the parties. All right, that is probably a lawyer's #1 job in a project financing: spot the risks and come up with a way that everyone can kind of live with them so that the project can continue. Now, as a general rule, as you can see on the slide, liability for project risks should be allocated to the party best placed to mitigate such risk, right? Or absorb the cost of such risk, right? So it basically means, right, that whoever has the broadest shoulders carries the biggest load, right? And that will vary from a project to project basis. But one thing that is generally true is that lenders are rarely the best party to assume any project risks. So lenders will robustly resist a contractual structure that tries to push risk onto the lenders, and will always push to be de-risked as much as possible. And similarly, the project company will typically only accept risks that it can control or transfer or insure against. And the lenders will also kind of push for that kind of risk allocation also. And I think an important point to note here is that this is a scenario where the interests of the project company, the sponsors, and the lenders may diverge, because sponsors are typically a bit more, have a bit more of a risk appetite, whereas lenders and the project company do not. So you don't always have alignment of interest in terms of the level of risk that the project company should assume. So what are some of these risks? Just very quickly, completion risk is a very obvious one. Will the project be built on time? Will it be built at all? Performance risk is another very obvious risk. Will the project be able to perform in a way that is required to generate the necessary revenues to repay the loan? Other examples include market risk. Will people buy whatever the project is producing? Political risk is one that often gets talked about, particularly in Africa. And that is really the risk of certain political events such as terrorism or changes in law. Physical risk, force majeure, environmental threats, etc. What happens if the project is damaged or affected by an act of God? And I think that the key thing about risk is that the first thing that project participants look for when confronted with a project risk is how such risk can be mitigated, right? And there are a whole host of mitigants available to a number of these risks. So for example, completion and performance risk is most commonly mitigated by having the project be constructed by a reputable contractor with a long track record of delivering projects, and having a construction contract, typically an EPC contract, that significantly incentivizes timely completion and on-spec performance, right? Usually through using liquidated damages. So that is a way of kind of addressing the risk or reducing the risk that the project won't be completed and won't be built to spec. Similarly, insurance can be an appropriate mitigant against a number of project risks, particularly political risk or natural force majeure risk. And this would mean that the project company would be paid insurance proceeds in the event that it can't operate if certain events happen and prevent it from operating. So I think the key takeaway from this risk section is that, as I said, as a lawyer, any lawyer can spot issues, any lawyer can spot risks. That's not hard. A good lawyer and a good project finance lawyer is always looking for solutions and ways that the risk can be mitigated or can be allocated in a way that enables the transaction to proceed. Bankability, very quickly. Bankability is a word that gets thrown about a lot in the project finance world, but not many people really know what it means or use it correctly. Bankability basically means a project structure and a risk allocation that is acceptable to lenders, and therefore lenders are prepared to provide limited recourse project financing to that project, right? And I think the key takeaway with respect to bankability is that it's a very fluid concept, right? There are no hard and fast rules about what is and is not bankable, and it's highly contextualized, right? And whilst there are general principles about what lenders would look for in a bankable project, what lenders will decide to finance will vary from project to project and will vary depending on a number of factors. So the common one is technology, right? So the newer the technology or the less proven the technology, it's considered to be inherently less bankable, right? Similarly, the location of the project. If a project is in what's classified as a risky jurisdiction, it's inherently less bankable than a project in a more settled jurisdiction. Similarly, the sponsors, right? The stronger the sponsor, the more reputable the investors, the more leverage they have over lenders, and the more comfortable lenders are accepting risks. So bankability, again, kind of evolves. And I think also bankability also depends on who is involved in the project financing. So we spoke a little bit about ECAs and DFIs and commercial banks. And each one of those institutions, or each one of those types of institutions, views bankability very differently and has a very different level of risk appetite. So I think, again, in summary, the key kind of takeaway when we're talking about bankability is that it is a fluid concept, and it's something that varies from project to project, and it's very contextualized. I think we've covered a lot of this about risk allocation, so we can move on from that. And we can talk a bit more about the key project agreements. So I think we kind of spoke when we looked at the structure, right, about some of the project agreements and commercial agreements. And I think an important point to note is that the number of project agreements or the types of project agreements you have on each project very much depend on the specific project, right? The size, the scale, the technology, the location, etc. But what I've picked out here is just a few of the kind of key typical project agreements that you would have on any project. And we are still going to talk about the finance documents, so I'm going to go through these very, very quickly. So my apologies if we can't cover everything in detail. So the first place to start is the host government agreement. Now, a host government agreement governs the relationship between a specific project and the host country that the project exists in, right? And it effectively sets out the terms on which the project will be developed and operated in the relevant country. Now, the ultimate purpose of a host government agreement is for the host government to effectively provide support to the project, right? And create a favorable investment environment and operating conditions required for the successful implementation of the project. And I think, you know, the key thing with the host government agreement is that host government agreement isn't required on every project. It's typically, you see host government agreements where in emerging markets, for example, or jurisdictions that are considered risky, or where projects require specific government support or intergovernmental cooperation. So a pipeline project is a very good example where you will typically always see when I say pipeline, I mean a kind of multi-jurisdictional pipeline where you would typically see a host government agreement and maybe even a government cooperation agreement between all of the various countries that the pipeline goes through, right? In developed markets like Europe, the US, where the projects have very little government interface, where there's much more of a kind of developed secondary market for these products and for utilities, etc., you typically don't see host government agreements, right? So this is not something that you will always see, but it's a very important feature on any project where you see them, right? And with a host government agreement, what you are really looking at from an investor perspective is, does the investor have the rights that it needs to be able to develop and operate the project? And more importantly, does the investor benefit from the protections that it needs, right, in order to be able to safely operate the project and monetize the project in the way that was intended? And the two kind of common things that you see in a host government agreement in terms of protections are stabilization protection, right, which is protection against adverse impacts as a result of the host country changing its laws, often known as change in law relief, right? And this is something you typically see in a PPA, for example. Another key protection is protection against expropriation of assets or shares in the project company by government entities. So the government basically saying, we will not steal your assets regardless of what happens, or if we do, we will compensate you for them. So that's host government agreements in a nutshell. I'd move on very quickly to talk about EPC contracts. Now, EPC contracts stands for engineering, procurement, and construction. And EPC contracts are effectively full service construction contracts where the project company, which you may remember is an SPV, it's a shell company, right? It doesn't have any people, doesn't have any money, doesn't have any expertise, doesn't have anything. So a lot of what the project company needs to do is done via third-party contractors, the EPC contractor being perhaps the most important. And when a project company engages an EPC contractor, what they are really looking for is, and when we say EPC, what we're really talking about is what we call an LSTK contract, which means lump sum turnkey. And what we mean by turnkey is that the construction contractor's job is to basically develop the plant on a turnkey basis, which means that once the EPC contract is signed, the contractor is obligated to, by a specified date, deliver the project company a working project that performs to agreed performance levels, right? So that all the project company needs to do once the works are completed is turn a key, switch the plant on, and it should be good to go in the way that was originally intended, right? In other words, an EPC or an LSTK contract is effectively a packaged construction solution, right? That is relatively hands-off for the project company and other project and the sponsors. Although in practice, excuse me, administering an EPC contract does require significant input from the project company and other project participants, but the principle is that it's hands-off as a packaged construction solution. Now, the key thing about an EPC contract is that it's supposed to give you certainty of performance and delivery, right? And the contracted performance levels of the plant, once completed, should enable the project to produce the requisite levels of product, whatever that product may be, to generate sufficient revenues to repay the proceeds of the project financing. Excuse me. And I think a key thing to note on an LSTK contract is that it talks about risk allocation, right? So the premise behind an EPC contract is that the main construction risks are, to the greatest extent possible, allocated to the contractor, typically using liquidated damages mechanisms to incentivize the contractor to deliver the contract or to deliver the asset on time and performing to the requisite levels, right? And this involves the EPC contractor assuming a number of key project risks. And important point to note from a commercial perspective is that the project company will often pay a premium for an EPC contracting solution, which means that they're basically paying the contractor for assuming these various project risks. I think I will stop there on EPC. There's a lot, we could do a whole 2-hour presentation on EPC, but maybe if there are any questions, we can pick that up shortly. And I'll move on to O&M very briefly. O&M stands for operation and maintenance of the project. And again, going back to what I was saying, the project company is a shell, it's an SPV, which means it may not, or is unlikely to have, the operational expertise required to operate and maintain the project. So what the project company will typically do is enter into a contract with a service provider, a specific operator, to operate the project on its behalf. And similar to the EPC contract, the aim of the project company with the O&M is to allocate as much of the operating risk of the project as possible to the O&M contractor. Now, I think the key distinction here, right, is that with an O&M contractor, O&M contractors are usually much less willing to assume project risk. And the reason for that is that they are usually much smaller entities. They're more thinly capitalized. The value of an O&M contract is much lower than the value of an EPC contractor, which are with much lower profit margin for the operator. And as a result, because they're getting less reward, they are less likely to assume project risks. And a common way to counteract this is for the O&M contractor to take a small equity stake in the project company, right? And that creates alignment of interest between the project company and the operator. And you can often use that as a kind of either a way of pushing more risk to the operator or a way that you get comfortable with the operator not assuming as many project risks. Another kind of increasing trend in the market is that the sponsors themselves, either directly or through a shell company, will perform the O&M services themselves, either by seconding their own personnel to the project company or using an affiliate operator, right? And what this does, it can either do one of two things. It can either save the project company costs on the O&M if they use a secondment model, or if they do it via an SPV or via an affiliate, the sponsors really then are creating an additional revenue stream, right? Which means that the sponsors are getting returns from the project as equity investors, but they also get paid a fee as the operator of the project. And what this enables them to do is basically create another high value revenue stream. The real advantage being that when you get paid as an operator, the operator gets paid first out of the revenues of the project, right? And because if you think about it, the O&M fees are a project cost, and project costs get paid first before debt gets repaid, which means that it's a very kind of quick turnover between the project company getting paid and the operator getting paid. Whereas when the sponsors are relying on their equity return, equity gets paid last, after you've paid project costs, after you've paid your debt and filled your reserve account. Equity gets paid at the bottom of what we call the cash flow waterfall. So when you have the sponsors also providing the O&M services, they get paid both first and last. It's a double dip effectively. Feedstock supply and utility supply. Very, very quickly, feedstock and utilities are basically the inputs that are required for the project to produce whatever it needs to produce. Feedstock really is fuel, right? And the type of feedstock will depend on the type of project. So for example, in a thermal power plant, natural gas might be the feedstock, whereas for a solar plant, the feedstock is actually the sun, the solar energy that comes down and shines on the panels, and that's what generates the electricity. For another example, a refinery, a crude oil would be the feedstock. So feedstock depends very much on the type of project. Now, as a general rule, feedstock is a lot more important than utilities. So I'll probably focus on feedstock very briefly. From a contractual perspective, perhaps the first thing that lenders will look for when they look at a feedstock supply arrangement is the term. So feedstock supply arrangement will need to be long-term. It will need to be at least for the duration of the debt, usually with a tail to give the lenders comfort that the project will benefit from feedstock supply and therefore be able to produce product for the duration of the financing. The other kind of key thing with feedstock supply is the allocation of supply and offtake risks, right? And typically a supplier will be obligated to supply minimum volumes of utilities corresponding to a certain level of production of the plant. And if it fails to do so, it will be required to pay liquidated damages. The feedstock supplier will obviously resist any kind of effort or any kind of attempt to get them to pay liquidated damages. So as a result of that, and also there may be caps on the level of liquidated damages that are paid anyway. So contractual solutions are not perfect. So lenders and sponsors will often look for kind of more practical remedies or mitigants to kind of address fuel supply risks, such as storage buffers or backup supply, or having plants that can run on alternative feedstocks. The flip side of supply or pay that we just talked about is obviously take or pay, where the project company may be obligated to take a certain level of feedstock, and if it doesn't, it will have to pay liquidated damages or take or pay payment to the supplier. Offtake agreement, I will just quickly run through this before I hand over. I think when we talk about offtake, it's a kind of catch-all term that is used to really describe the contractual arrangement or arrangements by which the project company sells all of the products that it produces, right? And offtake, as I say, is kind of used generically. And I guess the classic example of what an offtake would look like would be something like a power purchase agreement, where you have all of the product being produced by a company sold under one long-term offtake contract to a single customer. And this is very common in the utility space, particularly in the power and water space, where you have a centralized utility. But for example, in a refinery project or a chemicals project, for example, you may not have that kind of single customer long-term offtake, right? You may have, for example, a range of medium or long-term customers. You may have a mixture of long-term customers and opportunistic spot sales from the refinery or from the chemicals project. You know, there's much more flexibility in, I guess, what I'm saying, depending on the type of project that you are financing. And I guess another kind of limb to it is that on refineries and chemicals projects, for example, it's not uncommon to not have any kind of customer sales agreements at all. All right, sometimes these projects will enter into marketing agreements where they effectively deliver all of the product to an agent who will go and sell the product on behalf of the customers, right? And they'll do that in exchange for a fee. So the moral of the story here is that when we talk about offtake, there's no one way to do offtake or product sales. There are a variety of different structures, and the structure will depend very much on the project, who's involved, and the various different commercial dynamics. But I think the key point to take away here is that this will probably be the key focus of lenders' due diligence, because offtake, marketing, sales, whatever you want to call it, drives project revenues. Project revenues drive ability to repay debt. All right, so lenders will be incredibly focused, and they'll put all of the different kind of offtake scenarios, and they'll model market performance and all these different things. They'll put it in a financial model to make sure that they are comfortable that the sales arrangements around the project can support the repayment of the debt. I will probably stop there, given that we are short on time, but there's a lot more we can talk about offtake, and maybe we'll pick this up in the Q&A. Lachlan, do you want to talk about some of the financing documents?
Sure, thanks, Sam. Good afternoon to everyone who's joined in the meantime. For those of you who weren't here at the beginning, my name is Lachlan Palsty, and I'm going to talk sort of briefly now for the last 10-15 minutes or so, just in relation to the financing documents that you generally see on a project financing transaction. And so as Sam's explained, on one side, you generally have the project documents. That's everything between the SPV company and the different parties to ensure that the project is properly created and structured. And then on the other side, you have also with the SPV all the financing documents. So that's the contracts between the lenders and the SPV, which deal with how the funds flow to all the different parties. Maybe just one thing to also mention briefly is that when you're looking at project financing, you're usually looking at financings where there's multiple different lenders. So you'll have 2, 3, even 10, 15 lenders involved on the one project. And that's so that they share the risk, and that not one bank takes the entire risk on the entire project, but instead you have different lenders, each taking their own portion of the debt risk. And those lenders, as Sam said earlier in the presentation, they may be commercial banks, they may be Nigerian banks, they might be international banks, they may be international financial institutions, such as people like the IFC or AFDB, and they may be hedge funds or various other entities and alternative players which we're seeing in the market. And so the idea of the finance documents is to put in place the financing structure between all those different parties, ensure it's coherent, it works together, and to make sure that if things go wrong, the lenders are repaid, because as you all know, if lenders lend money, they like to ensure that they get it back at the end of the day. So what we thought we'd do today briefly is just sort of talk about a standard structure on the finance document front that you usually see on a project financing in Nigeria. The main document and the sort of the real backbone of the finance documents is the Common Terms Agreement. It's an agreement between all the different parties. Sam, maybe if we just go back to the previous slide, I'll just quickly run around the different documents and we'll get into the detail. It's the backbone. Then each lender will have their own facility agreement. So if you've got 3 lenders, you'll probably have 3 different facility agreements, and that puts in the specific terms applicable to each lender. As Sam said earlier as well, you can't get 100% debt usually. It's like when you buy a house, you need to show that you've got a deposit, that you've put in your own equity. And that's what the equity subscription agreement does. It's between the equity parties and the lenders, and the equity parties undertake to inject their share of the funds. The intercreditor agreement is the next one, and it sets out the relationship between the different lenders. And so voting requirements, what happens if one lender wants to enforce security and the others don't, is all set out in the intercreditor deed. You then have the accounts agreement, which, as the name suggests, deals with how funds flow through all the different accounts, the priority of payments, who gets paid first, who gets paid last. The security documents then and the direct agreements then deal with what happens when everything goes wrong. As Sam said earlier, on project financing transactions, the deals generally don't die completely. But the lenders will want to have protections in place, and they will either be used for actually enforcing the security and the debt, or for leverage to ensure that things are appropriately restructured. So that's just an overview quickly. And given we've got limited time today, it's probably some of the best summary, I think, in the slides of each of the different agreements. Sam, maybe if we just go quickly to the Common Terms Agreement, the slide, I think that's the next one. And so, yeah, as we said before, this is the backbone agreement where all the different finance parties are a party. You'll have the different lenders, you'll have the security trustees, the facility agents, and it'll set out the common rules and regulations which will apply to the financing. It will set out the covenants, the financial requirements, the mechanics for drawing down, the repayment dates, the events of default, the consequences, and it will combine all those different elements into one document. It's usually what you negotiate first, because it sets out the real commercial terms of what's being done on the financing. And I think the other point just to note is the terms of the CTA will really reflect what's happened on the due diligence. So Sam's talked about the EPC, the O&M contracts, etc. And what you'll usually do is you'll look at those project documents. The lenders will look at where there's remaining risks, and the CTA will set out how those risks are allocated between the different parties to the transaction. So maybe just to the next slide. Might skip over this briefly, but what will also be set out in the CTA is all the different financial ratios which must be met. So lenders are keen to ensure that if there are problems, that they're warned in advance of those problems. And one of the way of doing those is to have a financial model which sets out various different financial ratios, projected financial ratios, which must be set and must be met. And if things go wrong, that will mean you'll have an event of default under the documents a long way in advance before there's non-payment. So you'll look at the financial ratios, you'll do financial projections, and it may be that the financial ratios show that there's a problem in 1 or 2 years' time, and that's when everyone will start to sit around the table to sort the issues out and find a solution. The lenders don't want to wait until there's a point where there's non-payment before getting involved, and the financial ratios, and in particular the debt service cover ratio, are a key element of that. So facility agreements, as I mentioned, you'll have multiple different lenders involved in most projects. The facility agreements will set out the individual policy requirements and requirements of the lenders, and then also set out the sort of the mechanics of how you draw down. So who you need to send a notice to, how many days in advance, etc., for each individual lenders. because they may have different rules and requirements. They may also charge different interest rates on the same project. Different institutions have different pricing mechanisms, different incentives to be involved. And so those loan facility agreements, which are generally relatively short compared to the CTA, will set out those requirements. Next slide, please, Sam. The intercreditor deed, as I said, really sets out the relationship between the different financing parties. It's generally just between the financing parties themselves, and will set out things like what needs to be done if one lender wishes to enforce. So if you think about it, you've got multiple lenders involved in a project. You've got one security package over the entire project. And so if one of them wants to enforce their rights, that will then affect the others. And the time at which you enforce as well may affect the value of the project. So for example, in the current environment, you may not wish to enforce over an airport project, for example, because the value of airports at the moment is rather low given the unfortunate situation we all find ourselves in with COVID. And so you may wish to say, wait a few years for things to recover before you realize your security. And if one lender was just to go out and say, oh, well, I don't care about everyone else, I'm going to enforce the security and sell, that may mean that everybody gets less at the end of the day. And so what the intercreditor agreement says is, okay, so to enforce or sell security, to do X and Y, you need a vote amongst lenders, and you'll need a certain percentage of those lenders to approve an action before you can take certain steps. Maybe just quickly, because I think we've sort of reached the end of our allocated time today. Maybe Sam, if you just move on to the accounts agreement quickly. Again, that's an agreement which sets out the payment orders of how cash is applied. So if you think back to Sarah's presentation earlier, you've got cash coming in from the offtake agreements. In a power project, you'll have your offtaker paying for the electricity. The accounts agreement will then set out, okay, so you've had $100 of cash come in. How is that $100 allocated? And so at the top, you'll usually have tax, then you'll have operating costs, you'll have your debt, and at the end of the day, you'll have your equity. And the accounts agreement will set out some quite detailed elements of how that cash is to apply. And you can have all sorts of different requirements and different levels of complication of the waterfall. So what we call that stepping is the waterfall. And on one of the Nigerian projects I did a couple of years ago, the waterfall, so the rules of how you apply that $100 stretched out for 29 pages of different steps. And I think there are about 43 different steps in the waterfall. So they can become very, very complicated or much more simple. And you may have just 5 or 6, depending on the type of the project. And so finally, I think maybe just moving on quickly to security documents. I think one of the questions that people asked in the chat earlier was, do you necessarily need an SPV to do a project financing? And in short, I think the answer is yes, because what the lenders will require is share security over the company which holds the assets. And so if it's not an SPV and the company holds other assets, you're effectively giving the value of those other assets to the project finance lenders because they will insist on share security. So if you're a sponsor, you want to ensure that the only assets within the company which is over which their security is taken is the project finance assets themselves, which means in effect to do a traditional project finance structure, you do need an SPV. And so the share security is probably both sort of defensive security to make sure no one else can take the shares, but it's also practical if people wish to enforce. It means that without enforcing over each individual asset forming part of the project, lenders can, with more or less complications, depending on the jurisdiction, enforce security over the shares and then, sell them to a third party to try and recover some of their debt in case things have gone wrong. That said, it's relatively unusual to see share security enforced because if the project is not doing well, it tends to be a function of the environment more generally, rather than just the owners not doing what they should be doing to sort things out. So it's very much more a sort of a tool and a form of leverage at the end of the day than something that you'll see project finance lenders actually enforce. So that said, you'll take overarching share security. Lenders will also want to ensure that they have full security over all assets of the project. Again, that's defensive to stop other people having that security, and if things going into liquidation or insolvency, that they're first ranking over those assets. And it's also to ensure that they can, sell off the different bits and pieces if they have higher value for, individual elements rather than the sum of their parts. And it may also be that, there's different reasons for enforcing, and it may be that, there's other elements which are not doing well with the project company, which means that you may wish to sell the different assets individually if things go wrong at the end of the day. And so you'll take security of the land, buildings. You'll need to take into account, taxes, stamp duties, etc. In doing that. In some instances, they can be very large. You'll take security over bank accounts. That's probably the one that's used the most. If things go wrong, lenders may take some cash from the bank accounts. You'll take security over all the project contracts. So people might be able to step in and still enforce the EPC contract to ensure that the project's built, licenses, consents, shareholder loans, and insurances as well. So lenders will want to ensure that, for example, if the power plant is destroyed by a fire, there's to be an insurance payout, but that insurance payout goes first to repaying the debt before there's any funds available for the equity. And then finally, the other main document is the direct agreement. They can be direct agreements either with, as the structure there shows, a feedstock supplier, for example, or with the state. So there may be a concession agreement. You may be, for example, building a railway line. That railway line, your rights in relation to it are pursuant to a concession agreement. And the lenders will want to ensure that before there's any termination of those very important contracts for the project, that there's a discussion between the authorities or the feedstock supplier and the lenders. And so the authorities or feedstock supplier will need to come to the lenders and say, okay, there's big problems on this project. We want to be able to terminate the arrangements. You lenders, you're a very important element of this project. What are you going to do to make sure that we're protected and we can continue to be involved? And the direct agreement provides a real framework for those discussions and agreements and ways of finding a situation that meets all parties' requirements to ensure that the project can continue and is not simply terminated. Because if the project's simply terminated, the lenders themselves are unlikely to be repaid the debt, which is the ultimate aim for them as part of the project financing. So that's a very, very quick overview of the finance documents. They'll generally run to, the CTA will generally be 300 pages. And so if you add that with all the other documents, you're getting into very complex and lengthy documents with all sorts of different factors depending on the type of project. But the idea today was just really to give you a 30,000 foot overview of the general structures we tend to see on projects. And so with that, I'll hand back to Sam, who's going to be our master of ceremonies for the Q&A. And we're very happy to answer any questions that people may have on any element of project financing.
Thanks, Lachlan. That was great. I think, should we start with the Q&A that people have been submitting throughout?
Yes, Samuel. We should start with the Q&As in the Q&A box.
Sure, no problem. I'm just scrolling now. Lachlan, you already answered about the SPV. Do we need an SPV? That's a really good, you've already answered that. One question we had was around splitting of EPC work for tax efficiency. So that is something that is commonly done. So what you will sometimes see, and I think this is what the person is referring to, is you will see EPC packages split into what we call onshore and offshore work packages, right? And there are a couple of ways or a couple of primary reasons for doing that. The first one, which is something that's mentioned in the question, is about tax efficiency, right? So sometimes it may be beneficial to perform certain works offshore because there's a favorable tax treatment for them, or to perform certain works through an offshore entity because you can utilize tax advantages or tax treaties for the supply of goods and services from one country to another. So that's one example. Another reason is often because there may sometimes be local law restrictions on the ability of overseas companies to perform works onshore. So that's a common thing that you often see, for example, in Saudi Arabia. I think it's the same in Nigeria, but I could be wrong. That there are restrictions that only companies incorporated in that country can carry out construction work in that country. So as a result, what you will often see is a local company or an SPV or a branch incorporated in the company to perform the important in-country works, which will be the physical construction. And then you will have, for example, the parent company or another affiliate company, the EPC contractor that is based overseas, where they will do a lot of the design, the engineering, and the desktop-based procurement that is required for the project. So the split is very common to have it done onshore and offshore. And the important thing that you have to remember is that the whole point of an EPC, particularly an LSTK EPC, is that you maintain single point of responsibility, right? Which is where you have one construction contractor that is responsible for delivering the entire EPC work. And that principle prevails irrespective of whether you have one contractor, whether you have split onshore and offshore. And the way that you achieve that single point of responsibility, if you have a split, is that you will typically have what's called a RAP, or a coordination agreement between the two contractors, which effectively is a contractual agreement where one of the contractors, usually the parent company or the more solvent entity, agrees to take single point responsibility for delivering both the onshore and the offshore works. So you maintain that single point of responsibility and you maintain that package construction solution. I can't answer the question exactly of how onshore and offshore is tax efficient. I'm not a tax person, but as I said, it can enable you to use tax treaties and other loopholes, and specifics of that will vary from jurisdiction to jurisdiction and project to project. I hope that answers the question. I'm just going to scroll through.
I think the next one, Sam, was, does the SPV set up for project finance run its day-to-day operations like a regular company? If not, what are the exceptions in practical terms?
So
I can.
do you want me to answer that?
Go on.
Yeah, I guess I would say, I wouldn't quite say it's like a regular company. I think that the way that you start a project company can vary from project to project, right? And it will depend on how you are running the particular project. What I typically see in my experience is that you will see a project company run as kind of a hybrid, where they will have some staff to do some things. They'll have some operational staff, for example. They'll have local liaison staff to deal with kind of permitting and all of that kind of stuff. But a lot of the staffing up of a project company will come via secondees from the sponsors, right? And that's actually something that's quite beneficial, because typically the sponsors in these projects are established operators or established companies in the particular industry. And as a result, they have a lot of expertise at their disposal. So them being able to second their employees into the SPV is actually a way of them transferring their expertise into the SPV. And you typically see, for example, the senior managers being direct employees of the sponsors and therefore seconded to the JV and whatnot. But the project company exists, it's a normal company, there will be normal corporate governance requirements, there'll be a shareholders agreement, company law will apply. But I'd say probably in my experience, it doesn't tend to be staffed fully like a normal, or fully organically like a normal company would. But it could be done anyway, depends on the commercial rationale of the sponsors. Lachlan, what do you think?
Yeah, no, exactly. And I think maybe just one other point is that the contractual structure, so the financing documents, will impose lots of different requirements on the company as well. So it's a normal company would have full control of its management, its decisions, how it takes action. A project financing SPV will have to, refer to not only its shareholders but also its lenders in certain elements. And so the financing documents will set out, that they can't terminate X or Y contract without consent of the lenders. They can't make distributions without, meeting various rules, etc. So there's a strong contractual overlay as well, which you wouldn't have in a standard company.
Yeah. Another question that jumps out, I think it's an important one to address, is about dispute resolution in project finance transactions. And I think that's important because lenders, when they're lending to projects, are looking for security, right? Not just the security they take over assets and shares, that's literal security, but they want comfort that they are going to be able to basically avail of the rights that they have under the finance documents and the project documents, and if needs be, to enforce them. And lenders see kind of an effective dispute resolution mechanism as a key tool in their arsenal in being able to enforce their rights. So it's not just about having clear and extensive rights in the documents, it's about the ability to enforce them. And as a result of that, I guess, you know, as I said, dispute resolution is important, and lenders will typically want offshore arbitration, right? Particularly in emerging markets or riskier jurisdictions. They will typically want, particularly in the finance documents, governed by English law. Lachlan, I'm stepping into your area of expertise, so please correct me if I'm wrong. Governed by English law or another kind of commonly used international legal system, and offshore arbitration pursuant to institutional rules from a kind of well-known arbitral institution like the ICC or the LCIA. You may have some kind of what we would call local documents, like the land lease, for example, that would be governed by local law and may have dispute resolution in the local courts. In some jurisdictions where you have very strong national oil companies that will supply feedstock to the project, be it oil or be it gas or other chemicals, they may insist again on local law governed feedstock supply agreements with onshore dispute resolution. And that's something that we see very commonly in the Middle East, in Saudi Arabia and the UAE. Lenders do not like it, but because it's established market practice, they accept it and they find other ways to get comfortable with it. But I think typically project financing, especially where there are international lenders involved, will, like offshore arbitration in established jurisdictions. If you are doing more of a local financing, you may be able to get away with more local law and more local dispute resolution.
Samuel, do you also want to speak to the prioritization of the cash waterfall in an accounts agreement? Someone asked a question about that.
Lachlan, you want to touch on that?
Sure. So you'll have a variety of different accounts under an accounts agreement. The most, I guess, the main account will be your proceeds account. And so that'll be the account which you inject the revenues that you receive from the offtake arrangements. So maybe a power project, your off-taker of your power, the purchaser of your power, will pay you each month or each quarter the amount which is due in respect of that power. And so the idea behind the cash waterfall is to ensure that the project, the first priority, I guess, is to ensure that the project continues. And to ensure that a project continues, you need to pay your taxes and everything which is due to the state, because if you don't, they will come after you. Secondly, you need to pay your operating costs. So you need to pay your staff, you need to pay your leases, you need to pay your contractors, because if you don't pay them, then the project will stop and there'll be no revenue coming in. So the first two steps in the waterfall are generally taxes and operating costs. Next, you'll normally have some reserves which are put aside. So you want to make sure that your company has cash reserves to make sure that if things go wrong, they have some money on the side for a rainy day. And so you'll then, once you've paid for your taxes, you've paid for your operating costs, you'll put some money in what's called a debt reserve account. And so that's generally 6 months of debt payments that you put on a side to ensure that in future periods, if there's no revenue, the debt can still be paid. And then the other account that you'll generally have is a maintenance reserve account. So if you think about a project, maintenance is not due, every quarter or every 6 months or even every year. It's often due, say, after 5 years. And there may be, after 5 years, lots of money which is due and payable for maintenance. And so you'll start reserving those funds in advance to ensure that once the maintenance is due, that there's been cash built up to pay for that maintenance. So taxes, operating costs, reserves. At that point in the waterfall, you'll then generally apply payments towards debt. That it's your scheduled payment, any mandatory prepayments, and also any voluntary prepayments. Generally in that order. Mandatory prepayments, they may sort of come through other accounts, and you may have structures where you if there's insurance proceeds, those insurance proceeds go into a specific insurance account and then applied in mandatory prepayment. So it may not go through the general waterfall, but that's the general idea. And then once you've paid your debt, if there's any money left over at the end of the day, then that money, subject to meeting forward-looking ratios, and so there's been some questions about that and we can get onto it. The forward-looking financial ratios, if they have been met, there's cash available, then some of that cash will be available to distribute funds to the shareholders to ensure that the shareholders get a return on their equity. So if you think about it, tax is most important because you want the state on side, operating costs because you need your contractors to continue working, reserves, so like all of us, saving up money for a rainy day, then paying back your debt, and then finally the equity returns at the bottom of the waterfall.
Okay,
and then,
thanks.
Lachlan, do you want to talk about the DSCR? There's been a couple of questions on that. Sorry, I didn't mean to interrupt you.
Yeah, no, sure. And apologies, we're a bit short of time today, so I didn't get into the detail on the DSCR. As I mentioned just in the response now, the financial ratios, the idea of them is to ensure that the company is kept in a stable and financially solid position over the full life of the project. And so your debt service cover ratio will be a projection based on future cash flows, which are intended to be received. And so based on various assumptions that people make, there'll be a financial model, and that financial model based on those assumptions will say, okay, in year one, we expect revenues of 100. In year two, we expect revenues of 120. In year three, we expect revenues of 140. In year five, for whatever reason, revenues of 130. And so you'll have a forward-looking estimation of assumptions, of revenues, sorry. And then what you'll do is you'll look how much debt is due in those relevant periods. And so as long as the debt in the future relevant periods is say 90 or 100, it's well below the projected revenues, and therefore everything's fine, and there won't be an event of default. And if there's cash available, you can make distributions. And so the idea of the debt service cover ratio is to ensure that the debt service is covered by a multiple of the amount which needs to be paid. So the ratio will say, okay, in 5 years' time, as we said, there'll be 130 revenues. If in 5 years' time there's projected to be 100 of debt, then everything's fine because you have a 1.3 to 1 debt service cover ratio, and we're confident as lenders that we will be repaid our debt in those future years. If there's problems with a project and things start to go wrong, and the projections, because maybe the power plant's not performing as it was intended, so it's producing less megawatts per year than what was intended, you'll then redo your assumptions and you'll reduce the projected revenue. So in the scenario I just discussed, we said in year 5 there may be 130 of revenue, but that was based on the assumption that the power plant was operating fully correctly as it should have been. But if it's not, and you're seeing there's less megawatts produced, you may say, okay, in year 5 now we only estimate that there'll be 110 of revenue, but your debt stays the same. So your debt is still, that needs to be paid in that year, is still 100. And so the difference between the revenues projected to be received and the amount of debt which is due has become much smaller. And then that will mean that the lenders are in a much less comfortable position, because if something else goes wrong in the meantime, you're unlikely to be repaid. And so that's what lenders are looking at. They're looking at, in the future, are there specific certain multiples of the debt available to repay it, to ensure that in the meantime, now there can be distributions to equity, etc., or do we need to build up additional cash? So it's a real mechanism for ensuring that in the future, everything is fine, there's sufficient cash available to repay the debt and to meet all the other obligations.
Thanks, Lachlan. We also had a question about the debt to equity ratio. Do you want to talk about that quickly? Very simple, it's kind of a quick one.
Sorry, what was the question exactly, Sam?
Basically, what is the debt to equity ratio?
Recording in progress.
Sure. So the debt to equity ratio is generally an upfront requirement. So lenders will say, okay, if the project is to cost $100 million, say, the lenders will inject generally, will be willing to loan, say, 75 million of that 100 or 70 million of that 100. And so they'll say to the sponsors, okay, well, you need to put in equity of 30 million to ensure that the project is fully funded. So if the total project costs are 100 million, lenders will generally be willing to lend 70 to 75 million. And then the equity parties will need to put in their equity of 25 or 30. And so the debt to equity ratio is the ratio of 70 to 30 in that instance, because it sets out the requirements of funding of the different parties. And lenders will want to ensure that there's sufficient equity in the project, because, as you'll all know, equity faces the first risk. If everything goes fantastically, equity will get a big return. If everything goes wrong, equity should be the first ones which lose their money. And lenders will want to see a buffer so that if things go wrong, that they're still repaid in full. And usually we see a debt to equity ratio of about 70 to 30. And that's because lenders think that, in all likelihoods, they're likely to get the 70% back, but maybe not the 100. And therefore they don't want to have exposure beyond the 70% of the project costs.
Perfect. Thanks, Lachlan. I think we're out of time. I see Zelda joined. Hi, Zelda. Good to see you again.
We still have 4 minutes.
Hi, Samuel.
Okay. Hi, how are you?
I'm good, thank you. It's been a while. How are you?
It's been too long. It's been too long. We are just wrapping up. I think we can probably take one more question. Where are we at now?
So there's a question about a foreign company providing a guarantee for a Nigerian company taking a loan from a Nigerian lender. Are there any challenges with that? And if there's a challenge, what will be the remedy?
Yeah, happy to take that if you like, Sam.
Yeah, go ahead.
It will depend on each lender's individual requirements, but I don't think there should be a fundamental legal reason why a Nigerian bank couldn't accept a foreign guarantee. And it will all come down to where that guarantee is being given, what the legal structure applicable is, and how easy it will be for the Nigerian lender to enforce. So it may be that in certain countries, you're not confident in the legal system like you would be in Nigeria, and so therefore you may not be willing to accept a guarantee from a certain entity. Some of the, small islands, the financial havens, you may not be willing to accept a guarantee from some of those countries, or other countries have very strict rules on enforcing guarantees, and so it can be very difficult to do it. So you'd want to do an analysis of whether the rules applicable in that jurisdiction are acceptable, and how easy it is for a company for the bank to go and enforce that guarantee. If it's a recognized jurisdiction and the bank is comfortable from a policy perspective, there should be no reason, however, for not accepting that guarantee. If it's, say, I don't know, from England to Wales or another recognized jurisdiction, you'd normally see that being accepted on large projects in any event.
Yeah, very well said.
Thank you very much for that. So, I don't know, in the absence of any other question here that we think we should address, you may perhaps want to give closing parting shots, closing remarks.
Sure, thanks, Toby. Just to reiterate again, thank you to everybody for joining and for the really insightful questions. Thank you to the NBA for organizing this. It's been a fantastic program, and looking forward to seeing the rest of the presentations unfold. Please do reach out to us, connect with us on LinkedIn. Lachlan and I are on the website. Please email us. We've been a bit time constrained today, but we'd be more than happy to continue the conversation. And Lachlan and I travel to Nigeria, regularly. So, COVID permitting, in the new year, we'll be down there, and look forward to hopefully kind of meeting with some of you in person and continuing the conversation. But thank you once again.
Thank you, everyone.
Thank you so much. Lachlan, do you want to add something?
No, I mean, thank you very much for having us. It's a real privilege to be able to speak to you to all and you know, so many participants today. So really thank you for your time. And as Sam said, we're happy to answer any questions and meet with you. And I love coming to Nigeria, and so we're always happy to meet with anyone who'd like to do so. And so thank you again.
I'm personally looking forward to that. So thank you so much for sparing your time for us this afternoon and for sharing so much from the depth of your knowledge. We'll now move over to the next session with Zelda.
Thanks everyone, bye. And good luck, Zelda.
Thank you.
Bye.
Okay, so welcome, Zelda. And to everyone who is still on the call, I urge you to still stay on because we're about to have another wonderful power-packed session with Zelda. So Zelda is a partner in the finance practice group at 10+, which is one of the foremost integrated full-service commercial law firms in Nigeria. She has extensive experience in advising on both domestic and cross-border leverage finance, asset finance, project finance, debt and equity, capital markets, fintech, PE, and M&A transactions. So you can imagine how much wisdom, how much knowledge is being brought to the table this afternoon. Legal experience, of course, cuts across Europe and Africa. She's acted for various transaction parties, including lenders, arrangers, borrowers, trustees, project sponsors, purchasers, equity investors, and target companies. She has a Master of Laws in Banking and International Finance Law from the London School of Economics and is admitted to practice in Nigeria and England and Wales. I think I'm going to stop here in terms of a profile and just allow everyone else hear directly from her. So I'm not hogging the mic for too long. Thank you, Zelda. You may please proceed.
Thank you very much for that very warm introduction, and good evening, everyone, or good afternoon. I hope that this is not, the post-lunchtime tired slots where people are a little bit over the sessions and, not really able to follow. But hopefully I'll make it interesting, and, we'll have questions and let's see how it goes. I hope I can be as interesting as, Sam and Lachlan were before me. So I'm going to share my screen now, just to get my slides up. Here we go. I don't know, can everyone see my screen?
Yes,
okay,
I can see your screen, yeah.
Okay, great. And what I want to do now is I want to put it in slide mode. Please bear with me for one moment. I'm from an older generation. We don't know how to do these things. Okay, great. So we're in slide mode now, right? Perfect. Okay, so again, welcome everyone. Today we're talking about asset finance. And I've sort of been practicing finance at Templars and a few other places prior for a long time. So I'm hoping that I can make this interesting and informative. Just outline of what we'll be looking at today. So what is asset financing, right? I mean, very much like the name suggests, this is a financing approach or structure, let me say. They're financing structures that enable access for business assets without having to buy them outrightly. Now, there's a key word that I use there, which really does shape, the idea of asset financing, and that's access. It enables access, right? So it's not necessarily an outright purchase, but it is access to the asset. And if we can bear that in mind for the duration of today's session, that would be really helpful because it really does set the context in terms of what asset financing structures seek to achieve, right, for the individuals and companies that need them. Now, typically, you will have this, structures used for very large-scale assets. And in fact, once upon a time in my former life, when I used to sit in an asset financing group, we used to call ourselves planes, trains, and large automobiles, because that is really all we did in terms of asset financing, right? So you will see these structures used for, most popularly for aircrafts and ships, so the two most popular ones, but you'll also see them for all kinds of machinery, and also vehicles as well, not just heavy military vehicles, but even just fleets of cars and trucks and things like that. And then you also sometimes find asset financing in some very, very interesting corners of commercial markets. So for example, financing industrial freezers for food packaging companies, that asset financing can be used for that. In a very basic sense, though, it is another form of debt financing because there is a debt there that is incurred and a payment to be made. But one thing that I want us to be very clear about today is that it's not the same as asset-backed financing, right? There's a nuance, there's a slight difference between the two. So asset financing, like I mentioned, is the financing that enables access, right, to these assets. Asset-backed financing is raising capital, just as the name suggests, on the back of assets that the company has. And those assets can be anything from real property to inventory to receivables, but that's a session for another day, asset-backed financing. And maybe if we have a good time today, I can come back and do that if the MBA, kindly permits. But for today, we're looking at the financing of these expensive, large-scale assets that, tend to have a useful economic life. So the key characteristics for financiers, and I will use the word financiers because one of the things we'll see today is that asset financing doesn't always involve the direct lending, right, so to speak. But one of the key things that they will look at will be the asset value. That is extremely important. It's it's the crux of everything in terms of the financier's perspective. And then the other thing they want to look at alongside that value, of course, is that this asset is going to be the primary security. So a lot of characteristics about the asset will be relevant. So we talked about the value, the location, whether it's easily resellable, etc. And I mean, this is the introduction. We will, as we go along, kind of look at those and see why they're relevant to asset financing. Now, you might be wondering, why would any company or anyone in any kind of business venture want to do this? I mean, why do you need a special structure? Why not just simply borrow money and buy the assets, right? Isn't that like the simplest way to do it? After all, Zelda, you just said it's a form of debt financing. We have lenders and financiers. So why can't I just go to a bank, borrow money? So there are lots of reasons, right, why companies and business ventures might look at asset financing for some of these large scale financings. And there are also some disadvantages to it as well. But in order for us to properly understand why these structures are utilized so commonly in the market and why they're necessary, it's a good idea for us to have in mind the advantages from now and also the disadvantages as well, because you're all practicing lawyers and you may, at some point be faced with advising clients as to whether or not an asset financing structure is the optimum approach for what they're trying to do. So it's good to bear this in mind, Now, in terms of advantages, the key advantage, which in fact probably runs through all of these that I've listed here, is financial flexibility, right? Because like I mentioned, asset finance is all about enabling access to the asset, right? And being able to use it. But the company or the business venture or the individual doesn't have to pay for it upfront the way that you would for many of these, other assets. So it gives them that flexibility in terms of their cash flow, in terms of having reduced costs upfront, So for example, I mean, many of these assets I've mentioned, as you will be well aware, are very expensive. So we're not talking about $20,000. We're talking about shipping vessels of $30 million, and aircrafts in the hundreds of millions of dollars, for example. The idea that a company or a business venture or an individual will be able to have some structure that doesn't require them to put up all or some of those costs upfront, obviously will be extremely attractive from a commercial point of view, And flowing into that as well is cash flow benefits, because what the financial flexibility then allows that company or business venture to do, obviously, is manage their cash flow, manage their liquidity, because they're not having to make this huge capital expenditure. Instead, they can sort of manage their revenues and their expenditures a little bit better. Now, the other thing, and this will certainly depend on the asset, the structure being used, and sometimes even the jurisdiction that it's flowing out from, is that there can be certain tax advantages for the manner in which it is, structured, right? There's also the idea that there are no disposal obligations for the operator. Now, again, and I'm going to keep going back to this, in the introduction, I mentioned that these structures enable access. And one of the things you'll be seeing here is references to owners and operators. So when we say no disposal obligations for an operator, what does that mean? Well, remember that they're having access to utilize the asset. They don't necessarily own it, depending on the structure and the timing. We'll talk about that. But what it means is that they get to utilize the asset, full value for the life of it. And then at the end, they don't have any obligations in terms of disposal, how it's dealt with, and you will see and understand that as we go along. So for example, if you have obtained, say you're a domestic airline in Nigeria, and you've obtained an aircraft on an asset finance structure, right? When you come to the end of the time for which you want to use it, you don't have to worry about what do I do with this old aircraft, or what do I do with this, obsolete technology, etc. You can simply hand it back, right? And again, we'll discuss that a little bit later. But obviously that can be a huge advantage for many companies and business ventures. Again, going back to financial flexibility is the easier budget management. We talked about having your costs reduced and your cash flows, and all of that goes into the way that a company is able to manage their budget. So rather than having a huge hole in in one financial year because of this huge capital expenditure, they're able to sort of balance out the budget over the years a little bit better. So we're seeing how this is getting very, very attractive, and particularly so for new businesses, right? And I don't even think that's too complicated for anyone to understand, really. The idea being that you're a new business, and you may have a brilliant business model, great idea, but you don't necessarily have the revenue flow for these capital expenditure. You could even be a well-established business as well, and you don't necessarily want to divert your revenue to that, Now, it sounds fantastic. Why doesn't everybody do it? This is awesome. There are obviously some disadvantages, and these are the things that we weigh when we're advising our clients in terms of the structure they want to adopt for asset financing. So the very clear disadvantage, which for some clients, for some companies will matter a lot, is ownership in the asset, right? You, under these asset finance structures, typically do not have legal title. They don't have ownership. And that's why you've seen references in the advantages column to owner and operator. Now, there are some companies that will want to own the asset for various commercial reasons, right? And where that is the case, obviously, this is not ideal for them. This doesn't work. The other circumstances under which this doesn't necessarily work is short-term funding. And I'm not talking about short-term 12 months. I'm talking short-term like 90 days, the things that you might use commercial paper to fund. This is really not the sort of structure you can put in place for such a short term, right? It also typically tends to have fixed interest rates, and depending on the market, in the Nigerian market, that that could be more favorable, but depending on the market, that's something that the clients will want to look at and consider very carefully, right? If you're sitting on the operator side, then there actually are increased costs for you. And there's always a fixed term as well, which actually goes back and is tied into the legal title and the ownership. So you only have that asset for a fixed period. And obviously, this is not ideal to finance an asset that is needed permanently for the life of a business, right? It just doesn't, doesn't necessarily make sense. And obviously, there is some limited availability for this sort of financing for various assets. So in talking about these advantages, why we might advise clients to go for these structures or not go for these structures, I've referenced owners, I've referenced operators, right? We're in a finance session. We should be talking about borrowers and lenders and maybe security providers. Why am I talking about owners and operators? So let's look at some of the key participants in these asset finance structures. And again, this will be a little bit more clear when we actually examine the structures in detail. So typically you have the owner of the asset, right? And this will be the company that manufactures it or sells it or whatever. And in most asset finance structures, they will be referred to either as the lessor, sorry, I beg your pardon, not the manufacturer of the asset, but what you might otherwise call the borrower in a straightforward financing, right? So, i.e. the company or the business venture that needs the assets, that wants access to the asset, right? So the lessor or the purchaser, right? Now, very often that entity will actually be a special purpose vehicle that has been established but backed by a sponsor specifically for this financing arrangement. And then you have the lessor and the lease arrangement as well. You then have the user operator of the assets, right? And again, this will depend on which structure you're putting in place. But I'm just putting these terms out there so we kind of, get ahead and understand a little bit who the key players are. Then you have the financiers. Remember earlier I told you it's not just lenders in terms of commercial banks. We're all familiar with commercial banks, but very often on these asset financings, you also see your multilateral financial institutions. You will see very often DFIs, like AFDB, AFC, IFC. And then very, very interestingly, and it's something that you don't necessarily see in other forms of financing, so you will see what we call the export credit agencies, and we'll talk about them a little bit more, but they tend to be key players in large-scale asset financings, and certainly on several of the big ones that have happened in Nigeria, we've seen them play an important role. And then, of course, you have the manufacturers, the sellers, and the exporters as well. Now, as far as I'm aware, this is Friday afternoon. It's possibly your last session in a very exciting week of, finance law. So I know that you've already been had sessions in the other areas. And in fact, just before me, you had Sam and Lachlan talk to you about project finance. So why do we have all these different structures and approaches? Because I'm very sure from what they said, we could probably use a project financing approach for these large assets. Could we not? Like, why can't we do it? So in reality, there's actually a difference, right? Now, I have this table out here. I'm going to speak through it, but you can quickly kind of scan through, and it gives you a very, very quick snapshot as to what those differences are. So with asset financing, like I mentioned, we're looking at these very significant, major, tangible, movable assets, right? Like I said, aircraft, fleets of vehicles, ships, barges, vessels, etc., right? With project financing, it's like the name suggests, it's a capital-intensive project that you require funding for. Corporate finances are run-of-the-mill borrowing that we all know. When you look at the purpose clause in your facility agreement on corporate finance, I can assure you that 100% of the time it will say general corporate purposes, and it's usually to businesses that have an established track record. In the old days, it used to be described as investment grade financing. I'm not sure after all the financial crashes that they actually refer to any companies that way anymore, but that's how they used to be referred to. Now, in terms of how they differ from your asset financing, as I mentioned earlier, the value of the asset is key in this financing structure and approach. It's absolutely key. So your financiers, your lenders will focus on the value of the assets, right? And they're focused on it for a number of reasons, not just in terms of how much they're going to put up for it, but also in terms of, does it have resale value? Is there any value that can be recouped for it? Should there be a default or if things go bad, right? With your project financing, it's slightly different. The lenders will be focused more on the projections, right? The forecasted revenues and the cash flows from that project. So it's not as though the project itself has any parts that have value. Rather, it's what is going to come out of the project once it's up and running. And typically you will see that being determined by financial models. And for any of you who have already been involved in any kind of project financing, this won't be strange. And for those of you who are paying attention to the session just before this won't be strange either. With corporate financing, it's a little bit different. You have lenders focused more on the borrower, right? Like I mentioned, this is something that you will get if you are a business with an established track record. And so the lenders will focus on the credit and balance sheet of the borrower, right? Now, in terms of recourse, right, with your asset finance, you have there's limited recourse. And again, this is why we talk about the value of the assets, because really recourse is limited to that asset that is being purchased. Sometimes there might be a guarantee, and we'll talk about that in the various structures, but really the recourse is limited to that asset, right? Similar with project financing, that is non-recourse to the sponsors or limited recourse, but typically the primary recourse is to the project company, usually an SPV. It's revenue and assets, right? Not anything outside of that project. Project financing is really to ring fence. Corporate finance, full recourse, go for the company, all you want. Now, asset financing, secured. Project financing, fully secured. Corporate financing, usually not. Sometimes it can be secured, but not always, right? It depends on the commercial circumstances at the time. Now, in terms of due diligence, with our asset financing, I've already emphasized how much the value of the asset comes to bear on the lender's perspective and the financier's perspective. So as you would expect, the due diligence is focused heavily on the asset, very, very heavily on the asset. And obviously that makes it potentially less risky for the lenders. Their recourse is limited to the asset. They've done extensive due diligence on it. They understand the value. They understand the depreciation. They understand the resale value, if there's any to be had, etc. So that makes it potentially less risky and possibly more attractive for some lenders. With project finance, there'll be extensive due diligence. They look at everything. They'll do a risk analysis. And of course, it's a little bit riskier for lenders. With your corporate finance, like I said, we're really talking about more established businesses, right? And so there might be some due diligence on the borrower, not that extensive. Lenders typically take the approach that this is a less risky form of financing, right? But of course, it's not always suitable for capital needs. So it would not be appropriate, for example, to use a corporate finance structure to acquire a vessel or an aircraft, right? It just, it wouldn't work commercially and legally for a lot of reasons that we'll look at. So this first part was sort of trying to give you an overview, an introduction of what asset financing means and how it differs from typical corporate finance or project financing, which by now you'll be familiar with, right? So I think now we can kind of dive in and start looking at, the different structures and how they work and etc. Okay, so asset financing, there are two most common structures will be a straightforward sort of secured lending and then leasing options. And these are really the ways in which, they're done. But even though I've said it's just those two ways, there's a lot of room to play around within those structures. And so you will see a lot of different fancy, sometimes sophisticated, sometimes plain structures, all within the asset financing. What you have to remember from a legal perspective when, the financiers or your clients come to you with these structures is that they are trying to finance access, enable access to this assets, right? That's what you have to bear in mind, even though it will come in many different costumes, okay? I will talk about a couple of those, the more familiar ones, more common ones today. So like I mentioned, just a secured lending one, given that you've had a few finance sessions this week, you will be very familiar with this. Very straightforward. The lenders will lend money to the company, to a borrower to purchase the asset. The lender will then take security over that asset until you've repaid the loan, right? The asset remains owned and operated by that purchaser. It's on their balance sheets, right? And this could either be a loan, or you could even do it through the capital markets in terms of an issuance of notes, bonds, etc., right? Now, even though this is a recognized asset finance structure, it is the most basic of them all. And typically when we are talking about asset financing as a segment, as a class of structured finance, we're not talking about this because like I said, it's pretty straightforward. I will show you in diagram form right? So again, you can see it very clear, very simple. You've got the manufacturer, you've got the owner, you've got the lender. The lender gives a loan. That loan is passed on to the manufacturer for payment of the purchase price. The asset is passed on to the owner, and then the lender will typically take, I mean, I put mortgage in there, but it's really some form of security. But because, again, we're talking about these, large assets, typically we're looking at mortgages. So very, very straightforward. All of us will understand this, not really the depth of asset finance structures. So let's move on to leasing, which is where it starts to get a little bit interesting. And where, again, I want you to remember what we talked about in terms of asset financing being about enabling access to the assets, right? And this is where it really shows those colors in terms of leasing. Leasing is by far and beyond the most commonly widespread, globally used structure for asset financing. So if you understand no other structure, let's understand the leasing, right? There are some more complicated ones, but let's understand the leasing. Many of us will obviously be very familiar, of course, with leases and leasing. You have them in real property. It's not any different, right? So you have the owner, purchaser of the asset. They lease it to the party that needs it. In this structure, in an asset financing structure, that party is known as the operator. And the operator then pays in return rental payments, just like with leasing of, a house or an office block, for example. It's the same concept, right? Now, the operator, in making payments, those rental payments, might also assign certain rights that are associated with the asset that it is required to have. So, for example, it's required to take out insurance. But remember, again, the operator doesn't own the assets, right? So let me use it in a practical context, the most common one again, aircraft. So, Nigerian domestic airline carrier, they bought a plane. Obviously, the manufacturer of the plane that they're buying it from, and they've done it on a leasing asset finance structure, that entity that has leased it to them is not going to take out insurance, and all of this on the aircraft. What's going to happen is that it's the operator that's going to do that. However, because title, remember we talked about this, title, ownership, right, in that aircraft remains with the company that has leased it. What they will require is that you've taken out insurance, right? So I need you to assign that insurance to me. And the reason for that is that the owner that has leased the asset, because they retain legal title, they ultimately retain the value in the asset, right? The economic benefits in the asset. So the operator is utilizing it, but the owner maintains that economic benefits, the economic value. Now, because of that, obviously, they're going to be concerned with things like insurance because, for example, in the unlikely, heavens forbid scenario where there is a crash of that aircraft, right? For that owner that has leased it, who retains the economic benefit, who retains the value in the asset is gone. So what recourse do they have? Yes, they've taken some rental payments, but their asset is gone. And that's why they will want to have the rights of insurance, right, that the operator had taken out. So like I said, you have your domestic carrier, they've leased an aircraft and they've taken out insurance. In that awful scenario where there's a crash or for whatever reason the aircraft is destroyed, whatever insurance that should go to the domestic carrier as an operator would then go to the owner. Because of course there needs to be some, restoration of the economic value that they have lost because again, they remain the owner, they have legal title, economic benefits and value of that asset. The operator has simply been using it, right? We talked about how it offers flexibility, but again, this leasing structure, like I said, it's the most widely commonly used form of asset financing. And it's very important today that we really get a good understanding of it, right? Now, within this leasing, it doesn't stop there. Like I said, there's so many fancy structures that you will see, right, in asset financing. But we have two basic branches of leasing. So we have the finance leases and we have the operating leases. But before we go a little bit deeper into that, I'll just show you this structure chart, that just kind of gives, an overview, an idea of how it flows when you have a lease rather than lending. And you can see that the flow is kind of the same. What has changed, again, is that legal title, economic benefit, because rather than having owners, we have lessors, lessees, owner, manufacturer, purchaser, all of that has changed now. So there's a legal relationship there, right, that changes. And as lawyers advising on asset finance, excuse me, as lawyers advising on asset financing structures, this is one of the key things we need to understand, right? That legal relationship in terms of lessor-lessee. Because, and by the way, many financiers and bankers will tell you that as lawyers, you don't understand the finance part, just do the documentation. It's actually not true. We need to have a very, very good understanding of the finance part. I say that because it's all intertwined. So using this as an example, when we understand that legal relationship of lessor-lessee rather than manufacturer and purchaser, right, or lender and borrower, it then informs our legal documentation. It then informs how you can best seek to protect your client, whichever side your client sits on, right, of the documentation. So all of these things are very important. And it's part of why obviously the MBA has organized these sessions. So this is your basic structure with the lease. Now I think we can actually break it down a little bit and start talking about the finance leases and the operating leases as well. So finance leases, very simple, like the name suggests. And by the way, that goes for both of them, both finance and operating. So the finance lease, the principal purpose is to finance the ultimate acquisition of the asset. Keyword, ultimate, because from the day you enter into the transaction, you haven't actually acquired the asset. Remember, you don't have ownership, you don't have legal title. You have the right to use the asset, right? And we'll talk about that, just like with any other lease, things like quiet enjoyment, etc. But you don't ultimately own the asset. But sometimes the company, the borrower, the business venture individual will actually want to own the asset, but for whatever commercial reasons, be they cash flow, be they being at the beginning of a new business, they're not in a position to outrightly acquire the asset. So instead, they will utilize a finance lease structure, which then allows them to lease the asset with the ultimate objective of being able to acquire it at the end of the lease term. And the financing is what allows them to do it, right? So as you can see, what do we have? For most of its useful life, the lessee operator will have access to and use the asset. But during that period, what they will be doing, those rental payments that we talked about will actually be in such an amount and such a value and of such frequency that they will go towards paying off all or most of the initial acquisition costs, right? So to put it in very, very simple terms, say there is a vessel worth $25 million and we're going to, your client is going to acquire it via an asset finance structure, but they want to own it because they know that they're in this business for a long time, but they don't have the funds. So they're going to use a finance lease, right? What will happen is that over the period of the lease term, negotiated like everything else that we do, their rental payments will actually amount to what it would have cost them to buy outright. Sometimes a little bit more to account, for the fact that they haven't done that in the beginning. So a slight premium, sometimes, not always, right? But that's kind of how, so you can almost think of it like, installment payments is the way I've heard some parties talk about it that way, that they think of it, it's easier to think of it that way, like I'm just paying in installments, eventually it'll be my own. And I guess in terms of every day, the easiest way to think about it might be like, a hire purchase, for example, things like that, right? That's the easiest way to think about your finance leases for these large scale assets. So in a finance lease, the lessor, that's the party that has provided the asset, retains legal title, right? And then the lessee has this economic ownership that we were talking about with benefits to residual value of the asset, right? But even though they're using it, because they don't have legal title, they cannot create any security over the asset. And this is one of the key considerations, and we'll talk about it a little bit further on. But given all the finance sessions you've had this week, you'll understand very clearly by now about creating security over assets, legal title, etc. So I don't need to go too much into that. Suffice to say that without legal title, they can't create that security over the assets. And then, like I mentioned, they will have that option to either at the end of the lease term purchase it outright, or when the lessor has sold it on, any proceeds that they receive from that sale will actually go to the lessee. And that's because over time they've paid down via their rental payments the acquisition costs, right? So what you might find typically, I'm going from actual practicalities of what have happened in real commercial terms, is that you get to the end of the lease term, the lessee has been making all their rental payments. So they effectively, have paid the acquisition costs, right? But for whatever reason, they don't want to purchase the assets at the end. They don't want that ownership. It could be because, they want a newer model, or it could simply be because they're not in that line of business anymore. It could be because the technology has become obsolete. There are any number of reasons why, right? So what will then happen is that the lessor will say, okay, well, I'm not going to keep this asset. I don't need it. You're done with it. You bought it. I'll sell it, right? Those proceeds, anything above and beyond the complete acquisition costs, right? I will give to you, and I will just take what will make me whole in terms of acquisition costs. That's kind of the way it turns to be negotiated at the end of that lease term, where the lessee is not choosing to buy, right? But again, the other thing we have to remember is that the risks and benefits associated with owning and using the asset, of course, then become transferred to the lessee at the end, right? So, I'm sure there might be some questions, but I think there's time for Q&A at the end. So I'll move on now from the financing leases. The important thing to remember here, which is what we should bear in mind, is that this is a structure that is used ultimately for the acquisition of the asset at the end of the lease term, right? Now, operating leases, slightly different, but again, it's almost self-explanatory from the name, right? So they tend to be for shorter terms, less than the full economic life of the assets, okay? And typically the owner, original owner, right, manufacturer, for example, of the asset, might need to lease it several times in order to reduce that asset acquisition cost, right, for them. So what may happen is that the lessee may request extensions of their lease time, right? But again, the lessor continues to bear the risks and also the rewards, right? Because it remains the legal owner. It continues to have legal title, right? What that means, though, it has the risks of the depreciation in asset value, right? But there's also other risks as well. So for example, you have leased your asset to a lessee that then goes insolvent, right? There are going to be costs around that asset that you then have to bear, okay? So that's something else to think about as well, the insolvency risk around the lessee, right? Now, to mitigate their risks, typically you'll have a premium in these sorts of operating leases. And I talked about this earlier. So apart from your rental payments, they don't just represent what the acquisition cost of that asset will be. They actually account for just a little bit more because of that risk, right, that the lessor is taking. And again, just to refresh our minds, our memories, so we understand why they're taking that risk. With an operating lease, at the end of the lease term, right? At the end of the lease term, the lessee does not have the option to acquire, which means that the lessor is always going to own that asset. So when you own an asset for its life, for its useful life, obviously you bear the risk of whatever happens to it whilst it is in use by another party, right? So this is why lessors will try to mitigate their risks a little bit more on an operating lease. With a finance lease, yes, there are risks, but they tend to take, not as much of a risk-based approach to it because they understand that at the end of the lease term, it's going to be sold on. Not so with the operating leases, right? And if we look at an example of, some of those assets that it's suitable for will be things like aircrafts and ships, which have a very, very high capital cost, but not actually a high rate of depreciation. Because in that scenario, of course, the lessor is happy to carry on owning and holding on to the asset, even at the end of the lease term, because they know that there's been low depreciation value, and there's, there will always be other lessees who need access to this sort of asset, but because of the high capital cost, they can't get it, So, and that's why you have, for example, companies that are in the business of aircraft leasing. That's all they do. They acquire aircraft. They don't manufacture them, but they acquire them to lease them, right? It's a good business because, again, it's a long life asset, So that's kind of, high level distinction and understanding of the two primary lease structures that are used in asset financing, the finance leases and the operating leases, right? There's one important note I will say, and I know we lawyers like to wear many hats, so there may be some of us, today who are also accountants or interested in accounting, but even if we're not, it's important to note that since IFRS, so since 1st of January 2019, there's actually a difference in the way that leases are recorded on balance sheets. So prior to the 1st of January 2019, you would have operating leases appearing as an asset on the lessor's balance sheet, right? And we've just talked about why. I mean, again, self-explanatory. They still own the asset, right? And they're, receiving rental, and even at the end of the lease term, it still belongs to them. But with a finance lease, it's an asset for the lessee. And again, you can understand why, because there's that option to fully acquire at the end of the lease term. However, our clever accountants have changed that accounting treatment completely, right? So now both financing and operating leases are listed on the lessee's balance sheets. There are a few exceptions, typically where you have very, very short-term leases, maybe like 12 months or so. Those, would not be on the lessee's balance sheet. But now everything has been moved. The lessor as well, it's no longer necessarily considered an asset from an accounting perspective on their balance sheet. So it's just something to note. Reason being that when in practice, you have these conversations with your clients, etc., it might be something that comes up. They'll be saying, so what does this mean? Is this an asset that we own? And it will be important for them to know. And you would be saying to them as their legal advisor that, if you're using IFRS, this is the accounting treatment, but obviously speak to your accountants a little bit more about it, right? But again, it's something to note, the treatment, accounting treatment on the lessee's balance sheet, right? Okay, now let's talk about something interesting. Remember I said that we have all kinds of structures when you do asset financing. I'm going to be able to cover all of them today. I'm trying to go through the very common ones, right? But something that's sometimes interesting is combined structures. So sometimes you will find a combination of secured lending and leasing for these very, very high value assets, right? So you will have a lender finance and acquisition of the asset, but then there will also be a lease agreement as well, right? And that lease agreement between the operator lessor, one entity, the rentals that come out of that will be used to repay the loan. Okay, so let me show you that like with a diagram so it's a little bit more clear. I hope everyone can see this, right? So, maybe this makes it look a little bit more clear. So you have your lender here, right? Now you have what we call the owner, which will typically be a special purpose vehicle that has been incorporated just for this, right? And again, it's a way to ring fence, the structure and the financing. And then you have your operating lessor, your operating lessee, and you have the manufacturer. So this is, again, very simple. This is the SPV owner incorporated. There's a lender. The lender will advance a loan, right, to the SPV. The SPV will use that loan to purchase outrightly the asset, okay, from the manufacturer. What they will then do is enter into a finance lease with the operating lessor. Now, sometimes it ends there at that level, not often. Other times you will see that it goes even further down again to operating leasing. Now, it's important to understand that these are not necessarily unrelated parties, right? These are structures that are used to address all sorts of commercial considerations and commercial issues, okay? So you will see that this finance lease means that this entity will eventually own, right? Because it's a finance lease. But this entity here is only just going to operate under the operating lease. And you see it in, for example, businesses where this is a regular part of their business. So for example, we have vehicle leasing companies, right? It's rarely the same entity that is leasing the cars that owns them, right? Typically that entity probably has a finance lease on those cars itself as well, using this structure, right? And it's really to address a number of commercial issues. So we've talked about balance sheet, we've talked about cash flows, we've talked about financial flexibility. This is more where leasing of assets is a business, right? This is one of the ways that you can finance that. You may not necessarily find it where there's just a single high value asset to be purchased. But again, it depends. Sometimes if it is in the context of a, sometimes you get these fantastic transactions that are so complicated where you have a large scale project financing, and within that project financing, there's a large scale high value asset that is required to be purchased. So within the universe of the project lending, you then get a asset financing structure. And sometimes this is what you will see, right? Okay. So another interesting participant here, export credit financing, right? Another form of asset financing, but an interesting one. Now, all or some of us might be familiar with export credit agencies. And what are they? They are well, not quasi actually, they're governmental agencies in different nations, right? And what they do is that they're there to promote, industry and export within a country. And they do that by supporting export from a financial perspective, right? Of capital goods that originate from the jurisdiction. So I'll give you the most common example. The most common example will be there is a large-scale project in Nigeria, and it requires, a lot of heavy-duty machinery that is going to be imported from China, right? But the sponsors of the project in Nigeria can't necessarily afford to buy that machinery outright, or they can't necessarily afford, the payments immediately on the machinery from China. What you might then see is SEXIM, which is the China Export-Import Agency. So that's the Chinese ECA, step in because they're trying to support the manufacturer, right, of that machinery in China. They're trying to support them. They're trying to drum up sales, ensure, right? It's part of growing their economy. It's not charity. They're not ECAs are not NGOs, by the way. They're not even really DFIs because they are there very, very much to support their own nation's manufacturers and sellers, right? So what they might say in that scenario is, okay, Nigerian sponsor, you can't afford to buy this asset outright from this Chinese manufacturer, right? So what I will do is I will give the Chinese manufacturer a guarantee on your behalf, right? So I will guarantee it. So you take your time in paying so that my guy in China sells it to you, right? It's another angle to asset financing, okay? Sometimes it's not a guarantee. Sometimes it's insurance, right? And all of these things go to reducing the lender risk. On some occasions with, well-established borrowers, you may even see the ECAs actually outright provide debt on their own, right? Some of the very common examples that we see in the Nigerian market are, I talked about SEXIM, which is the Chinese ECA. There's Sinosure, which is the Chinese, it's an ECA, but they provide insurance, right? There's KXM, which is the Korean one. There's the Export Development Canada. There's SACE, that's the Italian one, and there's the UK Export Finance. These are all ECAs you might come across in the Nigerian markets, right? They are there to help their own nation's domestic companies sell in overseas markets, right? And so they will go to a Nigerian lender and say, I'll guarantee this Nigerian guy so that you are able to give him money to buy from the guy in my country. Or I will give him insurance so that if anything goes wrong, the asset is not, destroyed completely and there's no value to be retained. Obviously, these are things which go towards mitigating risk for lenders, but again, are another part of your asset financing structure, right? Okay, now, another angle to it, which is similar, very, very similar to what the ECAs do, is asset value support, right? Many of us will be familiar with what is known as vendor financing. So you're buying something from a manufacturer, but that manufacturer actually lends you the money to buy from them, right? Asset value support is similar, but it's not a loan. It will be similar to what the ECAs do in terms of a guarantee or an insurance policy, right? And the whole purpose of it is, remember, we said that the financiers are very, very, very focused on the asset value, right? So the whole purpose of asset value support is to maintain that value. So what the manufacturers are saying basically is that, if at any point during the life usage of this asset, the value falls below a certain level, then the manufacturer or the insurance that the manufacturer has taken out, right, will pay the difference in value. Because obviously from a lending financing perspective, that is cause for concern when you're losing the value in the asset. Because remember, again, that's all they have is security over that asset, right? I will note though that this is typically very expensive and not that common, right? In terms of the aspects you see in asset financing, the different elements in asset financing structures, this is not that common, but it's worth noting because it does happen, it is out there, and it's good for us to understand what it is, okay? So having had that overview of what asset finance is, what some of the structures that are commonly utilized are, let's now go on to the parts that, as lawyers, we'll be thinking about when our clients approach us to discuss them. And these are some of the considerations for asset financing transactions and the significant issues, right? The stuff that we really find interesting as lawyers. So, security package. Again, and I can't repeat this enough, I'm going to say it over and over again, right? The asset value matters because that's the only security that the lenders have, right? In this structure. So your security package, there's always a security package. It will typically almost always have a mortgage or some kind of fixed charge over the assets. You might see liens and pledges used, but not that commonly, right? Especially pledges, because in the Nigerian market, under Nigerian law, there's that possession element to a pledge, right? That might make it impractical. So fixed charge mortgages always. You'll also see, and we talked about this earlier, an assignment of the leaseur's rights in the lease agreement as well. And what that does is that it allows the financiers to step in to the lease agreement, right? So imagine, for example, that you have a finance lease, right? And you've gotten almost to the end of the lease term where they would have been able to acquire or something, but there are defaults, right? If the lenders step in, then obviously that then allows them to exercise the rights that the lessor should have in terms of, the rental payments or the right to acquire, etc. Right? There's also the assignment of any insurances over those assets, which we talked about. Now, the reason why is replacement costs. So if it's an asset that needs to be replaced, then obviously the insurance can go towards that. However, for the lenders, for the financiers, what any financier wants is their money back, right? So I have advanced capital for you to have access to this asset, and then it is destroyed for whatever reason, right? How am I getting my money back? How am I getting my capital back? Very often you'll find that is from insurance proceeds, right? And that's why they'll want to have an assignment of the insurance proceeds over the assets. I'm not sure if I've mentioned this in my later slides, so I'll mention it now, but I would hope that we are all familiar with the NICOM prudential guidelines, which prohibits assignments of reinsurances. It doesn't matter what they're over, right? And this is something that, in practice we have faced as a challenge very often. So if you are ever advising on this sort of thing and you have an international financier and they say, well, I know that in the Nigerian market, even though, assets might be insured, there's always reinsurance behind it. So I want an assignment of that reinsurance. Please bear in mind that that's actually prohibited under Nigerian law. NICOM does not permit that, right? So you might have to find, a workable structure around it. The other thing that you will see, of course, will be a share charge over the sponsor's shares in the lease. So this is where we have that combined structure, but typically it will be a share charge over the entity that is acting in that role, so that the financier is able to take over the company should they need to. Very similar to a share charge that you see on any other secured lending, right? So that's your typical security package, not too different from what you see in others. But where things differ with the asset financing structure tends to be around perfection, because these assets obviously are unique, right? We talked about them being large scale, high value. So generally, the security perfection is as would be in Nigeria. And I hope that after a week of finance sessions, everybody's very familiar with the slide that I put up. So I'm not even going to spend too much time talking about it. Stamp duty has to be paid within 30 days. If it is a company, which, on almost all of these transactions, it would be, you have to register that security at the CAC within 90 days of creation. There is a list of registrable securities in CAMA, section 222. And if you don't undertake the CAC registration, then you don't get priority that a security interest should give you, right? It's also important to note, if you look in CAMA, that not just mortgages, but any security interest that creates a floating charge is also registrable. It's worth looking at that list if you're not very familiar with it, right? We also have the National Collateral Registry, right? This is a relatively new registry. It acts as notice to third parties. What is interesting about it is that it was purportedly established for the registration of movable security in movable assets, right? So where you have cars, for example, vehicles that are being used as security, right? This is where you would go and register them. And similar to CAC, again, it's a registry. It would constitute notice to third parties, okay? So again, when we're the same way that you would conduct a CAC search to check if there's a mortgage against that asset in the first place, you would also want to be conducting a search at the NCR as well, okay? Part of general perfection steps as well, of course, will be delivery of notices of assignment where we've done those. So where you have an assignment of the lease agreement, where you have an assignment of the insurance policies, right? These are all, required to create that security assignment. If you don't deliver the notices, then you haven't completed the perfection steps, right? Another note, and this one I did put in because it's very important. The assignment of insurance policies to non-Nigerian residents is restricted. The reason this is very important is because when you come to advise, or if you are already advising on these transactions, you will see that very often when there's an international, financier, then they will either themselves or they will want, a security trustee that is international as well, right, to hold that security assignment. But Nigerian law doesn't allow it. So the way that we approach that, the way we deal with it, is by having those international financiers appoint a Nigerian security trustee, right? We also have, and this you can have the international entity being named as the first loss payee, okay? And you can also take security over what we call an insurance proceeds account. So, your borrower will set up an account that is specifically for any proceeds of insurance to go into, right? And they can take security over that. And I've actually been on transactions where the international financiers appoint a Nigerian security trustee just for the assignment of insurance policies and nothing else, because they don't want, they want their international security trustee or their international entity holding all the other security. I've seen that happen, okay? So these are general perfection steps. After this week, I'm very sure we're all familiar with them, but there are some additional perfection steps that are specific to large-scale, high-value assets that we've been talking about, which are typically financed under these structures, right? And let's talk about them because it's important for us to understand them, especially when we're advising the financiers, okay? So we'll just look at aircrafts and ship vessels for today. There's so many more, but this at least gives, a very good overview of the most common high-value assets. So with aircrafts, as we all know, the primary regulator of that space in Nigeria is the NCAA, the Nigerian Civil Aviation Authority, right? Now, typically, security is created over aircraft by way of legal mortgages. Now, you'll notice that I mentioned in the slides, if you're reading them later or now, that I said aircraft and engines, right? Which obviously sounds a bit interesting because the engines are part of the aircraft, so why separate security? So actually, on some large-scale aircraft, some big aircraft, some of the engines are actually separate, and they are, I can't remember the technical word now, but they are, I don't want to say constructed, but they are added on, for lack of a better word. There's a technical word, right, to the aircraft after it has been delivered. So they're brought separately. It's almost like, think of it like assembly, right? But because these engines are so large scale and high value on their own, sometimes they are also considered assets to be taken specific security over because they can be removed and reassembled, right? So sometimes you will see financiers saying, I don't just want security on the aircraft, I want security on the engine specifically as well for that time when it's removed and it's not actually attached to the aircraft, okay? But that's just a little, side fun fact for the day. So in order to perfect that security, right, it has to be, your mortgage deed has to be filed and registered, and we'll talk about it in a minute. Now, priority for mortgages, right? Two things will create that priority. There's registration, there's an international registry, right? And this was set up under the Cape Town Convention, which I'm really not going to talk too much about. I will leave that for your reading in terms of relaxation, right? But it is around, aircraft and what they do, etc. I'll talk about it in a minute. But under that Cape Town Convention, which is in 2001, the international registry that has been set up will confer priority. So think about it like CAC, and when you register security at CAC, how it gives you priority. It's the same thing, right? So if you register a mortgage over any aircraft at the international registry, it will give you that priority over subsequent security interests, right? Of course, it's a convention, so we have to be signed up for it to be enforceable here, etc. And I'll talk about that in more detail in a minute, right? In Nigeria, you also register with this NCAA, and as I mentioned, CAC, and that will serve as notice to third parties that you've created this mortgage, you have this security, right? And obviously, stamping registration will establish priority under Nigerian law, like security over any other assets, right? Then you have ships and vessels. That space primarily regulated by NIMASA. And similar to aircrafts, security over vessels or ships can be created by way of a mortgage, right? Very, very common. Sometimes you'll also have a charge. And it operates, the charge will be, a stopgap really prior to registration of the mortgage. So you might sometimes see where there's a charge and a mortgage, and it might be because registration of the mortgage might, take a long time, okay? Now, a charge over a vessel or ship can obviously be registered against the borrower's records at CAC. A mortgage over the vessel is registrable at the Nigerian Ship Registry. However, and this is an important caveat that I please want you to take away today, it is subject to the flag of the vessel. Some of you are probably maritime experts, practice in that area, and will understand, what that means. But the flag of the vessel is, where that vessel is itself registered. Think about it a little bit like incorporation of a company, right? And that's not necessarily the same place that that vessel is in use. So you might have a vessel in use in Nigerian waters or for Nigerian entities, but it doesn't carry the Nigerian flag, right? So whether you're able to register it at the NSR will be subject to the flag that it carries. So we can talk about those a little bit more detail. So aircrafts, now here is what is very interesting in Nigeria. The NCAA doesn't actually have a formal separate register of aircraft mortgages and charges. They don't. They're supposed to, but they don't, right? The civil aviation rules and even the Nigerian civil aviation regulations require NCAA to have one, but they don't. Actually, the language they use, which you'll see I've put in the slides, is NCAA is supposed to provide a separate registry of legal interest in aircraft, right? So it's not specifically speaking to security. That could be, an ownership. It's every legal interest, right? For every aircraft registered in Nigeria. It should show proprietary rights. It should show mortgages, liens, everything, right? They don't actually have that separate register. So in practice, what tends to happen is that your mortgages, charges, whatever other security interest has been created gets recorded in the aircraft file at the Civil Aviation Aircraft Registry. Now, is that really a disadvantage? Not particularly, because there is a registry. It's just not a formal separate registry, right? Of mortgages and charges. It just means that you need to go to the only registry there is where they've listed all the aircraft, and that's where it would be recorded. Okay. Now you can actually search that registry. You apply in writing to the NCAA and you pay prescribed search fees. Now, again, those searches will be part of due diligence, right? So if there is an aircraft in Nigeria that your client's interested in, that'll be one of the first steps you take, will be to see what encumbrances exist over it. Now, I talked about the CTC earlier, right? Two conventions that it's important to remember in aircraft financing is the Cape Town and the Geneva Conventions, right? The Geneva, I've been talking too much, I can't say Geneva. The Geneva Convention is much older, very, very old. It's like 1948, right? But that did start sort of the international recognition of rights in aircrafts, okay? But the Cape Town Convention, which is a lot more recent, from 2001, that now goes much, much deeper into international interest in mobile equipment and the protocols, right? There are protocols to that convention as well. And there are ones that are matter specific to aircraft equipment. So if this is an area that you are very interested in, or you become instructed on this, it'll be worth your while to go and do a little bit more reading and research on the CTC and Geneva Conventions, okay? But that's just an idea of the steps involved in specific security perfection over aircraft in Nigeria. Similarly, ships and vessels, again, we're talking large scale, high value assets. So it's not going to be the same as, registering security over land or shares, right? Now, a mortgage over a Nigerian flagged and registered ship or vessel is the most straightforward one you will do. It has a Nigerian flag, is registered in Nigeria, right? All you have to do is go to the shipping registry, and that's not a problem. Now, foreign ships or vessels can also be registered in Nigeria, but that's where they're on a bareboat charter, okay? And interestingly enough, I recently had a transaction where we were acting for the financiers for the acquisition of a vessel, but it wasn't on a bareboat charter, and it was flagged in Vanuatu. So we actually were faced with a real challenge in terms of perfecting that mortgage in Nigeria, the registration of it, because there isn't any avenue by which to do it, So it can sometimes get a little bit complicated, and then your lenders have to start talking about, the ways in which they can deal with that. On that particular transaction, what we did was end up registering the mortgage, right, in Vanuatu where it's flagged, which obviously is not a straightforward thing, but maybe what you have to resort to in the end, okay? So, like I said, security over foreign flagged vessels that are not bareboat charters are not registrable in Nigeria, right? unless, of course, they have been re-registered. So originally they were foreign, but then they were re-registered in Nigeria, then it's fine, right? One thing that is important to mention that is very typical with ship vessel financing, and we've talked about it, is the assignment of insurance proceeds, right? We would always expect this to be a condition precedent to disbursement, so to actual payment. And you recall that in your earlier sessions from the week, I'm sure you've addressed conditions precedent to disbursement. This is one of the things that any financier of a vessel wants to see, simply because they can be high risk, right? They're out at sea, So I want to know that you've taken insurance and you've assigned it to me so that I'm covered from the minute my money is with you to buy, right? And priority, we've talked about the registration already, and that's what gives the priority. The governing law, and this is an interesting one to note, will usually be the law of the flag of the vessel, right? Now, does that mean that every single time you are acting on a vessel financing transaction that is where the vessel is not flagged in Nigeria, that you need to go and get local counsel in that part of the world? Not necessarily, right? So I have acted, like I just mentioned, Vanuatu, we've drafted documents, simply because a lot of these jurisdictions that are popular for ship flagging will have standard form documents that you can use. But obviously it's something you need to do a little bit of research on, because it will depend on that jurisdiction of flagging, okay? So we've talked about taking security, and we've talked about the specific and general perfection procedures. So what are some of the other considerations in an asset financing? Well, retaining asset value. You'll remember from the very, very first slide in today's session, I mentioned that asset value is extremely key for financiers. Loss of value represents a bust deal, basically, right? Because there's no way for financiers to recoup the capital they have advanced. So retaining asset value is key, right? And not just for financiers, but with operating leases as well, also for the lessors, simply because they retain legal title and ownership, even at the end of the lease term. So it's not like a finance lease, remember, right? Where the lessor could acquire at the end, or they could sell to a third party and split the proceeds. With an operating lease, the lessor has to maintain it. So they need to ensure, right, that value is retained. So on these transactions from a legal perspective, what do we do? How do we protect the clients? How do we try to put in legal structures that will retain that asset value? So typically, right, these are, I'm telling you in terms of real practical advice and what we put in the documentation. All of the lease agreements will contain covenants and undertakings and obligations, including those that are restrictive, right, on the lessee in terms of what they can and cannot do with the assets, right? There will be a minimum standard of insurance to cover the value of the asset, to cover third-party liability, all sorts of things. Sometimes I've even seen financiers who are very specific about which insurer you can take insurance from, right? Which insurers they consider creditworthy enough to provide the insurance policy. They will go that far. It's all part of retaining asset value, okay? You will also sometimes see minimum maintenance standards. This is extremely common with aircraft, extremely common. So if you are being leased aircraft, there will be a maintenance schedule that you're provided with, right? And it's something that we try to work into the legal documents, especially if you're acting, on the lessor side, so that there is that obligation on the lessee to actually maintain the asset in accordance with those standards and the schedule. Sometimes though, you'll get a lessor, and this happens where they're the manufacturer very often, who will say, you know what, even though you're leasing it, right, I'm so concerned about asset value that I will undertake the regular maintenance of this asset, and then you'll pay me a separate fee for that. And then there'll be a side legal agreement that deals with that. There will almost always be restrictions on subleasing, except obviously where there is, a structure within a group for subleasing. But typically there'll be restrictions on subleasing. The idea being that the lessor is going to control visibility and, the asset and the risk of value loss. right? And then there will be specific conditions around the form and manner in which that asset is returned, okay? So there'll be inventory, there will be, status, all of these things. And these are obligations that we build into the legal agreement. So these are not just technical things. These are things that lawyers, all of us advising our clients, will have to ensure, depending on which side we're advising, have to go into the documentation, right? One caveat, which all of us will know from our basic, lease knowledge with real property, is quiet enjoyment. So we're not able to put into the legal agreements any undertakings or restrictions or obligations that will fetter the quiet enjoyment of the leasee. Because as we all know, that is a right that lessees enjoy at law, quiet enjoyment of the leased asset, okay? So these are some of the big issues, right? There are a couple of other ones, which I will just kind of, run through. And I think that you've probably addressed all, if not some, of these during the week while you've been having financing sessions. So things like exchange control issues and cross-border considerations, right? The value of the asset we've talked about over and over again. Excuse me, tax considerations, right? And remember earlier on I said that there are some tax structuring considerations and implications. So it'll be things like, will there be CGT on the disposition of the asset? So where we have that finance lease, which remember is for the ultimate acquisition of the assets, right? At the end of that, am I going to incur CGT even though I've been paying all these rentals, right? Is there going to be CIT on the interest on the rental payments? Is there WHT, right? If this is a cross-border international transaction, is there a double taxation treaty with the other, the other jurisdiction that we can take advantage of? And might that be a reason to structure it? Way back in the day, and again, I'm showing how old I am, right? Japan used to be a very, very tax-friendly jurisdiction for operating leases, so much so that there was actually a structure known as the JOL, the Japanese operating lease. I don't think it's so tax-friendly anymore for these operating leases, but this gives you an example of some of the considerations that go into structuring your asset finance transaction, right? Then of course you have regulatory concerns, both around proper registration of the asset. Again, we're looking at maintaining the value, right? Because you don't want any regulatory authorities or any issues around not having registered it properly, not being able to use it, it being seized, not having paid dues, taxes, etc., right? A good example of this is that all aircraft, right, to operate in Nigeria must be Nigerian owned and registered with the NCAA to operate. Now, obviously a long-term lease, right, would meet that like criteria, requirements, etc. But again, you have to register it. You have to go through those. You can't just, lease your aircraft, bring it in and start flying it within Nigeria. It's going to get grounded by NCAA. So again, these are things that you have to build in. An example of how we would build that into legal documentation is that it might become a condition subsequent, right? So that there's actually an obligation on the lessee to go through with that regulation. So those are some of the secondary considerations that would go into asset financing. And with that, we have come to the end of this session, and I'd be very happy to take your questions, if any.
So there are a few questions in the Q&A box.
Okay, let me see.
So I'm going to go through some of them.
Okay.
Yes. So someone has asked whether there are any special licensing, legal or regulatory requirements for facilitating a medium or large scale asset financing. I guess this is looking from the perspective of an advisor, whether there are any qualifications to undertake advising on such type of financing.
Okay, so in terms of the legal, right, being a lawyer advising on that, you don't need anything beyond your legal qualifications, right? However, for finance companies, leasing companies, brokering companies, lease brokering companies, there are all kinds of regulatory licenses and permits from CBN, SEC, depending on the way that you're doing it, so it really depends on what you're doing. But from the legal perspective, no, but from the finance perspective, yes, CBN, SEC.
Okay, thank you. Someone also wants some clarification. You said in a finance lease, the lessee has the benefit of the residual value of the asset. This is a bit unclear, especially given that the lessor retains title to the asset. Can you provide a bit of context to this?
Sure, and I understand why that might sound unclear. It's because you remember that, and you know what, maybe I shouldn't have said it so explicitly, and I apologize if that, was a little bit unclear. But remember that with a finance lease, right, the objective, right, is for the lessee to buy at the end of the day, right, to acquire. And even though if they don't acquire, to get some proceeds from a sale to a third party. So even though they don't have that legal title, they do have some economic benefit because the rentals that they are paying, the idea is that they will amount to the acquisition cost at the end of the day, which is why they have that economic value. And they derive it at the end of the lease term, either by acquiring the asset or sharing in the proceeds of the asset sale to a third party. I don't know if that clarifies.
I believe it does. Also, someone wants to know whether the Leasing Bank in Nigeria plays any role in asset financing.
Yes, it's an ECA like any other. So the answer is yes.
Yes. Okay. Close to that is.
I'm sorry, that should actually have been the first example.
Exactly.
On my slides. The reason that it wasn't is because on a lot of these large scale asset finance,
more Chinese.
Because the asset is coming from internationally, right? So those are the ECAs we tend to see. But apologies, I should have been more patriotic. Sorry. Next on that list.
Okay. Someone wants to know if there is an organization for the International Registry for Aircrafts.
There is, and I will dig it up and provide it. Can I send that across? Are we sharing the slides?
Yes,
later?
the slides will be shared later.
Okay, so I will dig it up and add it to the slides. Please, will you remind me, please?
I will. That's fine.
Thank you.
Okay. Someone wants to know what a bareboat charter means.
I'm not sure we have enough time to start going into maritime law, but it's just a form of ownership, right, of a vessel. And again, it's similar to the way we're talking about all these structures around operating lease and financing lease, right?
Yes.
Maybe I'll add a footnote. But what you need to understand, it's a form of ownership or form of, that allows you to have rights in the vessel to use it. But I can put in a footnote.
Okay. I guess to just also help the person to note that in that instance, the crew does not come with the ship or the boat. So
you just get the vessel.
Just
basically.
focus on the vessel, yes. Okay, so there is one more question. Where do you stand on limitation of a lessee to terminate a finance lease agreement?
Where do I stand on what? I didn't hear that.
On the limitation of a lessee to terminate a finance lease agreement. I imagine this question is coming from one premise that would be that you had said the lessee cannot terminate a finance lease agreement. So perhaps you can just clarify whether that was what you said.
Yes, so this is the lessee on, sorry, can you repeat that? Where I stand on lessee terminating?
On limitation of a lessee to terminate a finance lease agreement.
Yeah, so again, you have to remember, right? The ultimate purpose of the finance lease agreement is to acquire the assets. Okay, so it's a little bit like let me use very, very simple terms, a little bit like you have borrowed money to buy something and you've been paying for it. And then halfway through, you're like, I don't want to buy it anymore, right? There have to be, from the financier's perspective, there have to be limitations on your ability to do that. It's a commitment to the asset, right? So there have to be very, very limited circumstances under which you're able to do that. That's, you know, that's the conceptual, that's the rationale. Now, in terms of where I stand, I'm a lawyer, it depends on who I'm advising.
Yes.
If I'm advising, obviously I'm going to be fighting, you know, for very, very loose termination terms. But if I'm advising the financier, I'm going to make it as tight as I possibly can.
Yes, very wonderful response. So who pays the CGT for a finance lease? Is it a matter of contract by parties?
So
I guess CGT means capital gains tax.
Capital gains tax, yes. So you would expect it to be the lessor, right? Because they had that legal title, right? And at law, that's who would have the obligation, because essentially they are still, even though they've, you know, been collecting the rental payments, they've come to the end of the lease term. At law, they still have legal title, and that's the point at which they've sold. What you might find though is commercial negotiation, excuse me, around who will bear that cost, and you'll see it in your documentation.
Okay. Okay, and then one question on can you clarify the issue of amortization, reduction of the asset acquisition cost?
Okay.
I guess that ties into the explanation earlier about the rent being paid by the lessee, more or less helping to recover the cost of the asset.
Yes, I mean, when you think about it, and I don't know if it was covered in any of your sessions earlier, you know, this week, I assume that it was, but, you know, if you think about an amortizing loan, it's not like a loan where you have these scheduled repayments that are, you know, you're paying, very simple terms, you're paying, you know, 2 million naira every month, 2 million naira every month. With an amortizing loan, you know, what you're paying over the period, right, reduces, yeah? And so it's a little bit like that on some of these finance leases, because the ultimate objective is to pay over the rental payment period, the acquisition costs. So you're essentially paying down the cost of the acquisition, which is the way that, you know, an amortizing loan repayment would go.
True. One question here, that why are most asset finance transactions foreign exchange dominated? I guess that should have been denominated, even when dealing with regulators in Nigeria, such as NCA or NIMASA.
But that's where, why is the asset financing Forex denominated?
Yes, that's the question.
Because the manufacturers of the assets are abroad.
Yes.
They're offshore, right? This is why we need to start manufacturing more in Nigeria.
Hopefully we'll get there someday.
Indeed.
Yes. So I think this other question here has been answered. And then let me see if there's any new one. Okay, someone would really like to understand the concept of both sharing proceeds of sale to a third party. That is not so clear to me.
Okay. You say, okay, so again, with the finance lease, right? Remember that the idea is that at the end of the lease term, right, the lessee has the option to purchase the asset because their rental payments have been going towards the acquisition cost, right? But what you might have sometimes, it's not compulsory, it just depends on commercial circumstances, is a lessee who says, I've used this asset, I don't want to buy it. For example, maybe it's an aircraft and they're like, I want the newer model, right? I don't want this one. But they've paid the acquisition cost. They essentially have, you know, paid to acquire it, right? If you are a lessee in that position, put yourself in those shoes where you have essentially paid the purchase price, the cost to buy it, but you decide you don't want it, yeah? Now the lessor, they're not stupid. They're going to be like, okay, no problem. I'm just going to sell it to someone else. Don't you think that as the lessee who has paid the acquisition cost, you want a little bit of that cake? We're like, but you don't have any value in this anymore. Economically speaking, you've already recouped, right? The original lessor has already received their acquisition cost from the lessee, right? And that's recognized commercially. So the idea is that if you are in those circumstances, sometimes the parties agree. And I say sometimes because it's a point of negotiation. It's not a point of law. The parties don't always decide to do this. But sometimes what the parties will say is, okay, you're right. I have already received all of my full acquisition cost. I've been, made whole. I've gotten all my economic benefits, right? But you paid for this and I still want to sell it. So let's sell it, right? And maybe there's a little bit left to make up the acquisition cost. I can take that and you can take the excess, or maybe everything has already, been received and we will just share it, right? But that's the reasoning behind it, i.e. in a finance lease, the lessee has paid down the acquisition cost over time. So even though they're entitled to buy and own at the end, if they don't want to, they still want to enjoy some value from an asset that they've essentially paid for.
True. Thank you so much for that clarification. I see we are almost at the dot of 5 p.m. So on behalf of the NBA Institute for Continuing Legal Education, I'd like to thank you for making our time to deliver this presentation and also provide answers to the various questions we've asked. Thank you for sharing your knowledge with us and for giving to the MBA, because this is really important for this administration to ensure that more lawyers build capacity in different areas of practice. So we thank you so much, ma'am. And we hope we can call on you again at another time and you would oblige us.
I would be happy to be invited back. Thank you to the MBA for the opportunity.
Okay, thank you so much, ma'am. And so to everyone, thank you for staying on up until this moment and for participating in this in the training. The slides will be shared much later. All slides for all the sessions will be shared at different points in time, but you will definitely receive them. I can see a lot of messages in the chat box dropping their email addresses. Do not worry. So long as you registered for the training to attend the trainings, you will get the slides. So on this note, just going to say thank you, everyone. Have a wonderful weekend and see you some other time.
Thank you, everyone. Have a good weekend. Stay safe. Bye-bye.
Bye, ma'am.